No,
this
ma'am.
record is really for you, not me. If you want to appeal something, the Court of Appeals needs to see a complete record. So when you do, it may very well be blank because she can't interpret it. So I need you to just use words that can be found in a dictionary, okay?
Yes, ma'am.
All right, very good. So, do you know if she went to the hospital or suffered any injuries from that?
Yeah, she went to the hospital.
Okay, so there might be restitution, I don't know. So we'll talk about that at sentencing, okay?
Yes, ma'am.
And then as to the DNA, it sounds like they did not swab you. So I'm gonna have to sign a DNA order and you'll have to get that taken care of, okay?
Okay.
All right. And, on behalf of the people, any additional questions?
The people are satisfied, Your Honor.
On behalf of your client, sir?
No further questions, thank you.
Are counsel aware of promises, threats, or inducements other than those already placed on the record?
No, Your Honor.
No, Your Honor.
Is the court compliant with the court rule?
Yes, Your Honor.
Yes, Your Honor.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, count 2 will enter. Count 1 is hereby dismissed. Also dismissed are any outstanding warrants, if any, related to this file. Those will be recalled and dismissed. And it doesn't sound like there were any weapons, so I don't have to deal with that. And do we have a sentencing date? I can have one sooner than the 6 weeks. I don't know. Counsel, are you here on another date you would like to do this, or do I?
Whatever is soonest and appropriate for the court. I don't know exactly what dates I'm here.
Okay, I don't need a pre-sentence investigation report. I'm not going to tax the already overtaxed probation department. So do we have
The soonest on my book is March 18th at 10:30.
Does that work?
Yes, Your Honor.
All right, so I'm gonna talk to you about that in a minute, ma'am. So you will need to, and I'm sorry, you said at 10:30?
Yes.
Okay. So we're gonna give you a sheet and it says to call probation, make an appointment. You don't have to do that. You'll have to continue reporting to juvenile services, okay? So let me ask you a couple
Yes, ma'am.
questions if you don't mind. How often are you consuming alcohol?
I don't drink at all. I just drink off and on.
Okay, that's fine. And so, what I would ask you to do, and you do not have to do this, but it would, and I'll make a note, your attorney certainly is in front of me enough and he can explain it to you further. But you're gonna have enough time here where you could take anger management class. That also has a cognitive piece, because I will order that at the time of probation. So if you do that now, that would certainly shorten any probation I might. Or you could wait and start it in March.
So I actually is with CMH
Okay.
because I just lost my son.
Oh, gosh.
So I am talking to a counselor.
What happened?
So my son drowned,
Oh, my God.
yeah,
So
in
sorry.
September. So I've been, going to counseling to talk to them. Not often, but like when I get a chance, because I work like 6 days out of the week.
That's really great of you to go grief counseling.
But yeah.
Yeah.
I am talking to a counselor.
Yeah, he's still, there. He's just in a different form. So. Have you talked to your counselor about this? I don't want to violate it.
Yes,
Okay,
yes.
okay, so. Why don't you ask your counselor to prepare for your attorney and I a letter? You can give it to the attorney, he'll give it to me. And share with the prosecutor about you working on cognitive and anger management. And then that would fill in that requirement.
Okay.
Okay, so we'll just, she doesn't have to violate any confidences. I just want to know if you're attending, you're doing well, if there's any recommendations they have or what, that kind of thing. I
Okay,
don't need to know the rest, but what I would order here would be the cognitive piece to learn to make better decisions and the anger management. And you've got a lot going on, so I suspect she's doing all that.
yes,
So I just need some documentation of that's being done,
okay,
and that would help.
okay,
And in terms of costs, I'm likely to waive any other costs. However, the mandatory cost would be $198. There's the crime victims' rights, which is $130, and then $68 state cost, and I can't waive those. So those are not waivables. That's $198. So start saving your money. I'll give you time to pay that, but just if you want to kind of do one-stop shopping, that.
okay,
Okay,
yes, ma'am.
anything further, council? You can talk to her about those things.
I will talk to her, nothing further.
All right, I'll see you then, ma'am.
Okay.
Thank you.
Tyrone Howell.
And this should be on all 4 of his files.
Yes.
Yes,
All right, this is docket.
Yeah.
This is docket 25-5332 FH, 25-5593 FH, 25-5596 FH, and 25-4783 FH. People of the state of Michigan versus Tyrone Devontae Howell. Counsel, your appearance for the record.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Howell on all 4 files. He is present, stands to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth, whole truth, and nothing but the truth? And
Yes, Your Honor.
Thank you. And sir, have you taken any medication yesterday or today?
Yes.
Is it anything that would affect your ability to understand your attorney or this court?
I'm not sure.
Or, are you feeling okay today?
Mhm.
Is that a yes?
Yeah.
Ms. Schroeder, you had an opportunity to speak with him?
I did, Your Honor, and I believe that he is oriented to time, date, the situation he's in. I believe, though, it probably, based on the medications that I understand he's taking, he might be a little groggy. Is that fair to say?
Good, ma'am.
All right, are you so groggy, you want to do this a little later or another day, or you think you're understanding everything?
I'm okay.
All right, is there any medication that you're supposed to be on that you're not on?
No.
Any sign of fever, COVID, or other illness?
And
No, Your Honor.
one again.
Any sign of fever, COVID, or other illness?
No, Your Honor.
All right, thank you.
Yes, ma'am.
And this is a final criminal pretrial?
Yes, Your Honor. But we're in an odd situation because we were last here December 17th for a bond hearing where a litany of contents of the victim were discovered. The defendant effectively admitted to them and then said that he wasn't responsible due to his illnesses and the court sent for competency evaluation. We have already heard from the DHS that they need more time to do the competency evaluation. And so I asked that the final pre-trial conference be adjourned.
And so you asked the what?
So I'd ask that the final pre-trial conference be adjourned, so that way the competency evaluation can be completed.
Who's
How-
doing the competency, forensics or
Yes.
CH?
Forensics.
I'm
So
sorry.
he hasn't been sent there yet?
He has, Your Honor, if I may.
You may.
Thank you. A few weeks ago, he was polycomed with a doctor from the Center for Forensic Psychiatry. That doctor also reached out to me. I spoke with him. And then we received, there we go, a letter stating that he needed additional time because he wanted Mr. Howell to come to the center in person so he could conduct some additional testing, as well as receive records from the Lansing School District. And he has completed the additional testing, and now we're just waiting for the report and the records to be turned over from the Lansing School
Okay.
District.
I don't have copies of those letters, so, which is fine with me. I just need to know, do we have a time frame? Is it 6 weeks, 4 weeks?
I would hazard out, honestly, on the Arab side of caution of 6 weeks, Your Honor. We may get it sooner. Because I believe the letter I received stating he thought he could have it done soon, once he had the additional testing done.
Okay,
But we all know what the word soon means in the land of forensic evaluation.
Yes.
so can I do the following? Give you a date, just so he's not lost in the pool of all the cases that I have, and then we can move it backward or forward. However, if that, when that competency arrives, then we only have the 5 days and we'll have you in front of me one way or the other, but at that time, we have the competency review to see what they say. And if he's found competent, we also use that as a final pretrial date and then cancel the date I'm giving you, and then we move this case one way or the other.
The people have no problem with that. I think that's a good way to handle it.
I like one-stop shopping, and this
Exactly.
case is getting old very quickly. Is that all right with you?
That is fine, Your Honor.
Because that way you'll know what to talk to your client about, not just the report, but if it comes back competent, then you can also talk to him about the final pretrial.
Yes. And
Now, there is another matter.
Okay,
Additionally, when we were last here, because he admitted to the violations, you said if it comes back competent, he's already being found guilty of the contempt and being sent for 93 days. So that was December, what was it, 17th? December 17th. Since then, he has been sending the victim letters from jail using other inmate accounts. The jail sent us one on last Friday that was sent out December 29th. And then another one I received at midnight that was sent on the 22nd, so 6
Okay.
days ago.
so how is he doing this, electronically?
No, physical written letters through other inmate accounts. So he is telling her to add these other inmates, that way they can text with each other. And he's telling her to contact you to get the case dismissed. He told her to show up today and say that he's innocent.
Is she here today?
I do not believe so, Your Honor. But it's additional felony charges, and he's just not stopping.
Response?
I had received one of the letters last week, if my timeline is correct here. And then the second letter I was turned over to me about 20 minutes ago. So I don't know exactly what to respond to as to this, other than to say we are awaiting competency, Your Honor.
So there's a little bit of a dilemma because he's not competent and not able to follow my orders, that's one thing, but if it's in violation, willful violation of my orders, that's another thing. Sir, do you think that 4 files get better? 4 files turning into 6 files or 8 files is not good.
Yes, Your Honor.
Do you like being locked up in the cage?
No, Your Honor.
Do you like wearing that jumpsuit?
No, Your Honor.
Do you like the bed over in the jail?
Not at all, Your Honor.
How about the food?
Horrible, Your Honor.
Agreed. So the best meal over there apparently is Thanksgiving, and the second best is Christmas. You want to stay over there till Thanksgiving or Christmas?
No, Your Honor.
Then what are you doing, sir? I don't know if you're competent or not. I don't know what you're comprehending of this. You are responding okay to me. You have good eye contact and composure. I suspect that this is gonna come back that you need to stay on your meds to stay confident and all of that. I don't really know, I'm not a doctor, but let me, regardless, let me try to send you this message. I want you to think about it. All those things I just asked you, being in the jail, if you want to get out of jail, if you don't want to go to prison, then I don't know what all this is going to, how this is going to end up in the end. But even if you're sent to prison, the length of time based on your behavior could be longer than shorter. You've served quite a bit of jail, maybe you get out. I don't know, I can't pre-decide, but you are making it very difficult for me if it ends up in a sentencing situation to let you out, because you appear to be a danger to the victim and the community, as well as violating the law, not following the court's orders. So I have no belief that on probation, you would follow my orders. And if that's the case, then lockup is the answer. And sir, I don't do that just because of a whim. I take that very seriously. I'd rather see you on the outside, not costing taxpayer dollars, on bed space and taking care of you in the jail or the prison and getting you rehabilitated. But if you can't do that on the outside, we have to do it on the inside, and you aren't gonna like it very much. And I don't know how that helps your mental state. It's gonna get worse. Do you understand?
I hear you. I understand you, Your Honor.
So what about no contact that I've explained to you multiple times? Do you not understand? No contact means she doesn't exist in your world. No phone calls, no letters via handwritten email, no messages by carrier pigeon, smoke signal, third parties. You don't get creative, or what I have to do is call the sheriff and say, put him in max. Then you're in a little cell in a red jumpsuit. I'm sure you've seen the guys in the red jumpsuit. You're all alone for 23 hours and you get about an hour out. Is that what you want?
No, Your
Well,
Honor.
I don't want that either, because I personally believe that's cruel and unusual punishment and that your mental health will degrade. I am trying to do what's in your best interest, whether you believe it or not. But you have to be part of the solution, not the problem.
Yes, Your Honor.
So I don't know what's gonna happen here, but my docket is very busy, and I'm going to tell both counsel this. I may not take a full lunch hour. If my docket is congested and I'm gonna go into a trial that's 3 to 4 weeks, I'm gonna give you 15 minutes of my lunch hour each and every time he violates. And we're gonna see what happens. So I don't want you to wait 3 weeks. You follow the court rules, send out the notice, and you get him in front of me as soon as possible. And we're gonna continue this conversation and see what happens. My choices will be limited. So I suggest you understand that no contact means that Ms. Beauchamp does not exist in your world. Consider her gone.
Yes, Your Honor.
So you can grieve the loss of that relationship. That would be a really good thing. I can even have you go to grief counseling in the jail if you want. But she doesn't exist in your world. Sir,
Yes, ma'am.
what are you doing over there in the jail?
I go to class.
You going to cats?
Yes, ma'am.
Anything else?
MRT.
Okay. Well, are you paying attention? Because that's supposed to help you make better choices, and this is not a good choice.
Yes, Your Honor.
Anything you want to get done over there that you're not? While in jail, you want to get into anything?
No, not really. It's just been the depression dilemma stage, really.
Okay, are you See a doctor for that?
Mhm.
Is that a yes?
Yes, ma'am.
All right, well, if you need something, ask for it. Reach out to your lawyer. If the jail's not giving it to you, I will make a personal phone call. I do that all the time.
Thank you.
But you gotta help yourself, sir, because this is not helping you.
Yes, ma'am.
Your Honor, in terms of what people plan to do here, we're gonna wait to see the result of the competency evaluation. And then if it comes back competent before we file additional felony charges for each of his 3 files involving Ms. Bochamp, I'm going to be in contact with the defense attorney for, let's call it, significant negotiations.
Great.
And I will look forward to that. I also have informed Mr. Howell that I will be having my social worker connect with him as well.
They have an excellent social worker. Work with her. And let's get all this handled, sir.
Yes, ma'am. Your Honor.
But otherwise, you're gonna be seeing life through bars, and that's not pleasant, is it?
No, Your Honor.
So I'm gonna give you a date to be in front of me, April 1st, it's April Fool's Day. Make sure you're not a fool in front of me,
Yes, Your Honor.
got that?
Yes,
Message sent,
yes, ma'am.
April 1st at, let's just make it 10:30. Does that fit with everybody's schedule?
Not fit with mine, I'm going to be out for basically that entire week. Is there any chance we do it the following week?
Yes, let's do it the 8th.
Should work for me, same
8th
time.
at 10:30, sure, and that's only a place card holder, so it's in
Oh, yeah.
my docket, and then, again,
That's the backstop date.
that's, yes.
If we're able to do an earlier date and get the report back, I am always on board with that plan.
Great, so you all know the plan. So place card holder, we got the 5 days, and it will be 2 things. And so you'll make sure you work with my office and staff, let us know.
Absolutely, Judge.
Right. Anything you're not getting in the jail?
No, Your Honor.
Great, no more letters, no contact. She doesn't exist in your world, she's gone.
Yes, Your Honor.
That's all for the record, thank you.
Thank you, Your Honor.
I'll get, her name's gonna be Sophia or Beth. I gotta double check my file. Okay. Okay, take care, Tyler.
Let me just ask, it doesn't have to be on the record, but I just wanna, might as well ask it out in the public, so the prosecutors and counsel here. I don't know if there's any thought, but I'd like you to take the message to the prosecutor and the assistant. And maybe we can get a message out in the jail. The people who are assisting in these, all of these people violating the no contact order should be co-conspirators and charged as such, so that if the message is sent,
We have tried that in the past. The difficulty has been district court judges finding that there was the necessary knowledge or intent on part of the inmate whose account was used. So we have tried to go down that road, but very frequently they will say, well, we don't know for sure. The other inmate knew that he was assisting this man in violating the bond or talking to a witness.
well, then let's get the sheriff involved, put some notices out, like it says, you are being recorded. If you assist another inmate, you will be.
I will say the jail, when they find that and they figure out, or they find, hey, these are the inmate accounts that have been used by this person, who's not supposed to use the phones, they do receive penalties and punishments in the jail system. It's just
Yes,
not
well,
criminal charges.
I think we need to, this is a frequent, you guys are frequent flyers on this issue, so we need to. do
No one
something.
more than me, Judge.
All right,
Trust
so,
me, I know.
so let's figure this out collectively, because this is just, we got all these people waiting, and this is a constant problem.
Yep.
So, I'll take care of it, if I have legislature, that's good, we'll figure it out with the legislature. All right,
Thank you. Your
message
Honor.
sent, thank you. Next man.
Maybe Stuckey.
Should be 2 files.
This one's at 10, Judge. Page 10.
This is docket 253159FH and 253479FH. People of the state of Michigan versus Tyrants Lamar Stuckey. Counsel, your appearances for the record.
Good morning, Your Honor. H.P. Bucks on behalf of the people of the state of Michigan.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Stuckey on both files. Mr. Stuckey is present, stands to my right.
Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
You may put your hand down. Have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
Have you had enough time to speak with your attorney?
Yes, ma'am.
Do you understand that this is a final pretrial? And I have those, so we have a look at whatever you want to do, and if you want to plead, that's fine. I don't care what you do. If you want to go to trial, that's fine, but I have to have a cutoff, because I don't generally, maybe once in a blue moon, I will allow plea for a special circumstance on a date of a jury trial, but we call in jurors. It's a lot of expense and time, so if you would plead on a day we have called in jurors, then I don't have somebody else, and so somebody else has lost their ability to have a timely trial. So I don't want you to feel pressured, but it is in a way a bit of a pressure, because today is the day you got to make a decision. Do you understand that? Yeah, all right, so on behalf of the people, what is the plea offer? Was there one, I should
So,
say?
Your Honor, there has not been a plea offer yet. It looks as if, so there has been contact with the victim in this case, but unfortunately, because I've been in court and dealing with trial, I have not had a chance to talk to the victim personally about a plea offer in this case.
Well, she isn't driving the bus. She gets to say yay or nay. So what offer is being considered? Is that even, this is a final pretrial.
We have not had an offer.
Go work it out. No, this is a final pretrial. My docket is not gonna get stuck by this. So have a conversation today. Everybody has a right to a speedy trial, and you call the victim. I'm here all day. Let's see what we can work out today. And then we'll talk about another date if needed. This is just not acceptable.
Your Honor, if I may ask the court, Mr. Stuckey, is he able to, well, Mr. Brexton and I try to work out something.
He can go about his business. Just keep your cell phone on, sir. You got one?
Yes, ma'am.
Great, keep it on and answer the phone.
Yes, ma'am.
And then if we need to have you come back this afternoon or tomorrow, that's fine. But this is how cases get old. And if the victim is hard to reach or whatever, then maybe they're not interested anymore. And it's the people's call. Victims are unhappy all the time about the offers. They don't get to drive the bus. It is the prosecutor's case. They have a say.
And I understand, Your Honor.
Thank you. It's all for this record.
Maybe Carlos Anthony next.
Thank you, Your Honor.
Thank you.
What was the next one? Carlos Anthony. That is with the AG's office. At night.
And I'm present, but my video is disabled by the host.
Yeah, we're gonna fix that. Can you fix that? Okay, we're gonna fix that in just a moment. So try it in just a second. Actually, I didn't even put mine on. All right, there you are, sir. All right. This is docket. I'm sorry, this is Anthony. Yep. And there's two, are there two files? I only have one listed. Is the final pretrial on both or on one?
It's just on the one, Your Honor.
All right, thank you. This is docket 23-131 FC, People of the State of Michigan versus Carlos Lee Anthony. Counsel, your appearances for the record.
Good morning, Your Honor. Michael Doby, P76671 for the people.
Thank you.
Good morning, Your Honor. Ronald Berry appearing on behalf of Mr. Anthony, who is standing to my left or right at the podium.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide you the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
You put your hand down. Thank you for wearing a suit. I rarely see defendants wearing suits, so appreciate that. Okay. Have you taken any medication yesterday or today?
No, ma'am.
Alcohol, marijuana?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
You had enough time to talk with your attorney?
Yes, ma'am.
And has there been a plea offer in this? This is a final pretrial.
There
This
has
is
not
a
been,
final.
Your Honor, in discussion with the defense
I
attorney.
can't, sorry, sir, you need to stay closer to your mic. We can't understand you.
I apologize, Your Honor. No, there has not been a plea offer made in this case. In discussions with the defense attorney, it was made clear that the defendant would only accept a misdemeanor, so there was no real negotiation beyond that.
Counsel?
First of all, I don't discuss the subjects of our negotiations. We had a conversation. I don't know that I ever said that he would accept any offer, let alone whether it's misdemeanor or felony. In this matter, he maintains his innocence, and we've negotiated as such. Where we're at right now is Mr. Dovey had indicated to me 3 months ago that he was going to follow up with law enforcement about getting discovery that's outstanding, and I haven't heard anything since. We don't have the body cameras, the motor vehicle camera videos, anything of that. I understand this is the AG case was transferred to the AG's office for William County.
Wait.
But this whole, we don't have it.
Stop a minute. This is a 23 case. Sir, how is it this information has not been given to counsel? 2 years, 3 years. What's going on here?
Your Honor, a lot of the things that he has requested simply don't exist. 4 body cam videos were located by a subsequent search by the detective sergeant now
A subsequent.
on the case.
You gotta stay
and
next to the
has now-
microphone. So you said a lot of what he's requested doesn't exist. And then what did you say?
4 additional body cams that had not been previously provided to my office were provided. They have been provided via a download link to Mr. Berry this morning.
Via a what? Oh, via what?
A download link, a link to download.
Download link, okay. So is there outstanding evidence that you have not provided to defendants in 3 years?
No.
Are you?
Well, frequently, Your Honor, I'll have to talk to Mr. Dobie to find out when this stray email must have been sent for me to download some additional body camera. It's interesting. I'm being told that much of it doesn't exist, which what I'm asking for is body cameras and dash cameras. And then in the same vein, being told 4 body cameras are sent to you. I don't know. I guess I'll have to look at them. But I know there's lots of law enforcement that were involved with this. They're referenced in the police reports, and to be simply told they don't exist, I want to get some follow-up on here. I guess I'll have to file a motion to compel, and we can get evidence.com records to prove whether or not they exist and what efforts Mr. Dobie has taken, if any, to actually retrieve them.
Okay, I have a solution here. And Court of Appeals is down the road if neither one of you like it. So today is the, what, 26th? No, yeah. My brain's already February. Today's the 28th of January. Whatever's outstanding or whatever, can this be figured out by February 4th?
Oh, not that quick, Your Honor.
Why not?
Well, I currently have another.
Don't care. Because they have to come up with it, not
Okay,
you.
there's only one me, and I have lots of words.
I know you do.
So
I know you
that
do.
quick, I cannot.
Wait a minute, you have a list of what you need, right?
Yeah.
Okay.
Well, I mean, I don't know what exists. By all police.
Not your job.
Yeah.
Not your job. Sir, turn over everything that exists.
Yes, Your Honor.
You
That's
can
happened.
go through, it's gonna take 10 seconds. You could do it right now. I'm happy to wait. You can go through your email on your phone. Just don't say anything yet. You can go through your email on your phone, whatever, and look, and if you never received it, I'm inclined to dismiss this.
Well, that part we clarified.
Okay.
He gave me back in November a download with 172 files. We had a screenshot, and I confirmed with him that I have downloaded those, and that even in his own material, that those do not include law enforcement recordings. He's at least providing an update that there apparently he found 4 police videos. I don't know. He's never emailed or communicated with me about that. But if there's a download,
when did
I'll
you
download.
find those 4?
I'm sorry, I didn't find them. The detective sergeant now, I have no access to evidence.com or whatever the Lansing police use. But the additional 4 videos, so the entire reference 176 items. So sending everything again was sent this morning to Mr. Berry, like within the last half an hour.
Oh, so the 4 additional cameras were sent this morning, and I've received no additional information. Okay, now I understand.
Okay. Let me
They
understand,
didn't exist before this morning, apparently, Your Honor.
how long has this? Here's what we're doing. This case is dismissed. You
I'm
all
sorry,
get
Your
your
Honor,
act-
there's been no motion to compel. There has been, you're dismissing these because, only
I'm
because
dismissing these, so you
Mr.
go all
Barry
get your
says,
act together and you can reissue it. This file is 3 years old. This man is due a speedy trial and this information is not new. I rarely do this. I can't think of one time in 22 years I have done this, but this seems to me to be unfair and prejudicial, and you can reissue. You can take your time and reissue when everything's put together, and then we're gonna do all this again. And am I causing taxpayers money? Yes, but you know what? This man has been reporting to pretrial services for 3 years. The date
Your
of
Honor,
this offense
respectfully,
was.
he is
Yeah,
not. This
respectfully,
has
if you
been on
interrupt
2
me again,
years.
you will be picked up and put in lockup for contempt. So I'll give you a chance to talk, but you will not interrupt me, especially when you're on Zoom, and I've given you the courtesy to not plow through the snow like everybody else, and you're on Zoom. This offense occurred February 15th, 2022, and I am not a judge who just dismisses things lightly. And you can ask everybody in this town, you can go down to the Court of Appeals, and you can do whatever it is you want. But this man has been under our charge for 3.5 years or so. And things have not been turned over until now, and now I'm hearing they need more and more time. There's constitutionally protected rights. When you all get your, and there's no statute of limitations on a life offense. So when the Attorney General gets their act together, so will everyone else. This is dismissed for lack of progress and prejudice.
Your Honor,
That
I
is
need to
my
make,
ruling. Court of Appeals down the road, yes?
can I make a record here, Your Honor?
You can make whatever record you want as long as it's respectful and don't interrupt me again.
Absolutely, thank you. Yes, Your Honor, this case was charged by the Ingham County Prosecutor's
Can you
Office. It
start
was
over?
almost a
Yes,
year
I'm
before
sorry, you
the
have to stay,
AG.
sir, it's my court reporter, you gotta stay near your microphone. The Zoom, for whatever reason, is not picking you up very clearly.
Thank you, Your Honor. This case was originally charged by the Ingham County Prosecutor's Office. It came to our office approximately a year after that. For about a year and a half since I've had it, the defendant was on bench warrant status, not reporting. He is, despite repeated violations before and after that. I don't believe that there is any basis.
After that?
I don't believe that there is any basis for dismissing
Just a
this
moment,
case.
sir. It dropped after bench warrant status.
He's on bench warrant status, not reporting.
Yes, Your Honor, he was on bench warrant status following a violation. He was, so just on the idea that he has been reporting to pretrial services for 3.5 years, that's not accurate.
Well,
I
let
don't
me
believe
just
that there
say
is any
this.
basis for this dismissal based on the defendant.
Sir, you gotta start again. The court reporter's not picking it up.
Your Honor, I don't believe that there is any basis in law for this dismissal based on the defendant's claim that there is additional discovery that has not been provided. There has been no order to compel, no motion to compel, and no showing that there has been any wrongdoing by any party here.
Okay. The bench warrant that I have was in 2024. We are in 2026. The first witness list that I have here from the people was in 2020, let me see, 2024, August of 2024. This is a final pretrial. My expectation on a final pretrial is that you are all ready, not that we go back to square one like when he was charged. And you certainly can file a motion for reconsideration or do whatever it is you want to me, but this is truly unconscionable here. In August of 2025, he was held in contempt and served 17 days. So between August and now January, there was plenty of time for this evidence and the files from both sides to get in order. I don't know why we're at final pretrial, and now there's claims of things that have been in possession of law enforcement and the Attorney General, and I suppose the Ingham County prosecutors for all these years and not been turned over. So as far as I'm concerned, a lack of progress is violating a fundamental right to presumption of innocence and freedom. And believe me, I don't do this lightly. I understand these are life offenses. They're very, very serious. But so is the lackadaisical attitude, maybe on both sides, maybe on all sides. I don't know, but I'm not going to stand for it. The resolution is to either file a motion for reconsideration or simply recharge defendant. No, we're done with this file.
Your Honor, may I ask the court issue the order so I don't have to worry about an objection, 7-day rule and all that?
There's one right there, print it, we'll send it over to him and I'll sign it. Just
Thank
do
you,
the
Your
blank one. I'm not, so sir, I suggest you're not skipping town, you got another file in front of me. I suggest that you are the most law-abiding person on the planet. I don't like what happened here. I don't like these charges. I don't like this whole situation. But you do have a right to a speedy trial and a right to have an exchange of information that is timely. And this is simply disturbing. And I know everybody's busy. No one knows that more than me. And I had 100% criminal docket. I get it. But this speaks to laziness on your part, your counsel's part, the prosecutor's part, the Ingham County prosecutor's part, and that's not a justice system. That's a lazy system. That's not what I'm gonna tolerate. So message sent, they may very well reissue, so I suggest that you deal with your attorney and maybe you continue working on this. I really don't know. I'm not giving you legal advice, but they do have the option of reissuing this immediately, and they can do that. But message sent, I hope. That is all. I'm gonna sign the order. We're gonna, council's writing it. We're gonna send it to you, sir, for approval, or I'll just read it now in the record.
Yes, Your Honor.
All right, this matter is dismissed without prejudice for the reasons stated on the record. Any objection to that, counsel?
No, Your Honor.
On behalf of the Attorney General?
None beyond what I've already stated.
Great, send a message to your office. I expect timeliness, especially on a final pretrial. Y'all get your ducks in a row or this will happen. I don't know what else to say. I have not done this in 22 years. But this does not sit well with me. Well, make sure you all get a copy of this. That's all for this record.
Thank you, Your Honor.
Counsel, you have a next date on the second file? I hope.
I believe there is one, yes, Your Honor.
All right, thank you.
The next thing we're gonna do is Tyrell White.
No. Could you approach, please? Both counsel?
Do you want to wait for later then, since it's?
I need everyone not associated with this case to be out of the courtroom. We'll call you back in a few moments. Thank you. Do you have anybody on Zoom?
No.
Okay, so just put us into the court and do you know how to do that? Do you have someone here with you?
Yeah.
Who is that? Those of you online, we will be with you in just a moment. We're going into a confidential hearing. You just go.
Yeah.
Yeah, they changed it. Try more. Yeah, I don't know what they changed. You get to show us because they changed the choices again.
That was trended on whether they had to transfer me. Yes.
Instructions.
Pizza.
No, but what?
Cheese and pepperoni.
And you have to, you got a couple,
Yes.
or so we have some stuff for Jews.
Yes.
I have a spinach and chicken.
Okay.
You good, looks everything looks good.
Okay, we are now unmuted. This is docket 19-425 FH, People State of Michigan versus Melvina Kajar, formerly known as, or also known as Melvina Lockett. Counsel, your appearance for the record.
Good morning, Your Honor. AP Buckner on behalf of People State of Michigan.
Good morning, Your Honor. Larry Schneider, appearing on behalf of the defendant.
Good morning, counsel. And Ms. Kajar, could you unmute yourself and? Yeah,
Yes,
put
I'm
your
here.
camera on. Does she have the ability for a camera on?
Check.
Okay, just a minute. We're gonna give you
I'm
the
here.
ability to put the camera on.
Do you have that file, Judge?
I don't.
Okay, I got it right here. Just don't have it labeled with the.
Okay, I'm here. I'm on,
All right, you're good. Thank you. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
yes,
Thank you. Put your hand down. On behalf of the people, any objection to this set aside?
Your Honor, our office has received a letter from the Attorney General. That letter states that looking at her criminal history, it appears that she may be eligible for conviction as long as her circumstances and behavior warrant the setting aside. So at this point in time, Your Honor, the people leave it in the court's discretion.
Thank you. And counsel, what would you like me to know?
Thank you. Just a couple of questions. Do you prefer, can you tell the judge how you came to change your last name from Lockett to Kajar?
yes, I changed my last name from like HR. I had got married back in,
Okay, ma'am, you need to stay closer to your microphone. Don't worry about how we see you in the camera, how it looks. We just need to hear you for the court reporter, okay?
okay, can you hear me, better now?
Much, thank you.
Okay. Yeah, so I changed my name from Lockett to Kajar. I had got married back in, 2017, 2018. I'm actually working on a divorce now. I had got married to the wrong person.
Do you have any criminal charges pending against you at this time?
No, I haven't did anything since then.
And have you been convicted in or out of the state of Michigan of any crime since the one that we're seeking to have expunged today?
No.
And I believe you told me that you have something you want to read to the judge?
Yes, I do.
You may proceed.
Okay, so my name is Melvina Kajar. I'm 25 years old. I'm going on 26. I had a trouble past. I was dating the wrong person.
Sorry, ma'am, you gotta keep, stay by the microphone. Let me just ask the court reporter where to pick up.
I'm going on 26.
Oh, I'm sorry. Is it my phone? Maybe I should go towards the living room area and get better signal.
It's not your phone, it's that you need to stay closer to the microphone. When you're closer to the microphone piece, we can understand you.
You guys talk slower too.
You gotta talk a little bit slower, enunciate, and you can just make your voice a little louder. It might sound to you like you're shouting, but it won't sound like that to us, okay?
Okay, sorry.
It's okay.
So my name is Melvina Kajar. I'm 25. I'm going on 26 in March. So my case was back in around 2018, 2017. I was kind of around the wrong crowd, which is my child's father. He's in my documents as well. His name is Marvin Kajar. He's in prison right now, actually, for drugs. He's on probation for drugs. So I kind of was around the wrong crowd, and I kind of took the rap for somebody, and not like intentionally. I think it was out of love. It's my son's father. I'm currently trying to go to school and try to become a nurse. I've been doing the classes, but I cannot get into the nursing program with, of course, with drugs on my background, because they're saying that I would have to get a complete expungement. I haven't done anything since then. I haven't been getting in any trouble. I've been trying to go to school. Right now I'm currently working from home. So that's why my phone was kind of set up on my computer set up, but they told me I can definitely attend court. This is very serious, very important to me. And it's something that I would really like to put in my past. Everything I do, including jobs. I barely got the job that I have right now. I have a son. He is 6 going on 7. The person that it's kind of emotional to talk about, but the person that gave me these charges, his the son that I have right now is by him actually, so that's kind of why I took the charges, which is something that I'm exposing to the court. My son's father, that like it's just what he has done since a child. He had a rough growing up, and I knew that by me being pregnant by him, I'm like, well, I don't want him to go to prison, so that's kind of why everything landed the way it did. I'm not a criminal. I don't do anything outside of go to work, go to school. And I'm just trying to make the best life for me and my son. I wrote a paper, but it's just something that I can generally say that I want to put behind me, and just make my life better for me and my son. I would want a career for myself because with my record like that, I won't be able to get one at all. Based off the things that I want to do, I want to get more into the medical field, maybe start off like as a medical assistant. But right now, I've been just accepting job offers. A lot of jobs have been denying me. Like, I barely got the one I got now, as I said. But they accepted it because they said it's the only thing I've done in my life, and they'll give me a shot. But yeah, it's just something that I really would like to put in the past, put behind me. Um, I'm kind
Man, what
of
have
shaking.
you learned from this? I've heard a lot of excuses. I'm not happy about the excuses. I get that, you made some poor decision making, but what have you learned from that poor decision making?
Well, what I've learned from that is definitely to stay away from the wrong crowd. Let people take their own rap, and really trying to make I'm not really trying to make excuses. I have learned a lot actually from this situation. I've learned never to take anything for someone else, but it's no excuses. I've also learned that I definitely will have a horrible record. I will never be able to get a good job. I will never be able to get a career. Um, I will never be able to be the full potential of what I want to be if I, like mess with my record and things like that. And I may not be wording it right because this is just coming directly from me.
All right, counsel, anything further?
I have nothing further.
Thank you. Now, you really need to always stand up for yourself and not follow the crowd and not do something for some man because, in the end, you got a really bad outcome. And you're right, having a record, a felony record stops you from all of your potential. It just is a huge roadblock. I am going to grant you what you seek. I think we need some good nurses and there's a shortage and you certainly deserve a future. You had to live with this. It does sound like you've learned from it and you've decided to finally be your own person, making your own choices and your own woman and live your life, not for someone else. And I think those are important lessons. So an application to set aside the following conviction was filed on November 10th, 2025, delivery of narcotics less than 50 grams, and the date of that conviction was May 19th, 2020. The court finds that Michigan State Police has reported the required information from its records to the court. The applicant has not been convicted of more than 3 felonies. The applicant has had no convictions for an assault or crime set aside under the statute during their lifetime. There are no criminal charges pending against the applicant, and the applicant has not been convicted of any criminal offense during the applicable time period required under the statute. The applicant is requesting that a felony offense punishable by more than 10 years imprisonment be set aside, and the applicant has not previously had a felony conviction for the same offense set aside pursuant to the statute. The time period required by the statute for the conviction listed in item 1 has passed, And an opportunity has been given to the Michigan State Police, the Attorney General, and prosecuting official to contest the application, and no one has. Circumstances and behavior of the applicant from the date of the applicant's conviction to the filing of the application more than warrant and justify setting aside the conviction, and it is consistent with justice and public welfare. Therefore, the application is granted as to the conviction listed in item 1, and pursuant to the statute, the Michigan State Police shall maintain a non-public record of the order setting aside conviction and of the arrest, fingerprints, conviction, and sentence of the applicant in the case to which this order applies. If the court or arresting agency maintains a record of the arrest, biometric tag, conviction, or sentence, that record shall be non-public and not used for any purpose unless authorized by law. This has been dated, signed, and read in open court. And ma'am, if you were here, I would ask you to approach and hand you this document and shake your hand. So you're not here. You're in Texas. It's a lot warmer there, I hope. But this is a rebirth for you. And I'm going to make sure you have a copy of this. We'll give it to your lawyer and it will be transmitted to you. It will be in our records today. I have an excellent clerk who will make that happen. I do not run the other departments, wish I did, but they take maybe 4 to 6 weeks at most to do this. If it does take longer, your attorney can contact me and I will certainly make a phone call and make sure this does happen for you. As the last order of this court, I'm ordering you to take that wonderful son of yours out for a celebration dinner.
Thank you so much.
Can you do that, ma'am?
Yes.
All right. That is all for this record.
Thank you so much.
Thank you so much. That's why I like to do these.
Yeah, you too. Thank you.
If you just hang tight, sir, I'll get you a copy of this.
Oh my God.
Thank you.
Thank you so much, Judge Aquilina. You just changed my life.
You changed your life. All I did was acknowledge your accomplishment, ma'am. You changed your life. Take all the credit. I don't deserve any of that credit. You do. So go out and celebrate with that in mind, okay?
These are tears of joy. Thank you so much.
We're gonna do Amber Sager next. It's at 11.
Good morning.
This is docket 25-1034 FC, people of the state of Michigan versus Amber Darlene Sager. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Amber Sager, Your Honor.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be true, whole truth, and nothing but the truth of the company perjury?
Yes, ma'am.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
I
Are you
just,
supposed to be on medication you're not on?
I'm supposed to be on mental health meds, but the fact that I go through withdrawal symptoms, I haven't taken them because I'm pregnant. And I don't want my daughter to have to go through that.
Okay. And so without the medication, how are you doing?
Some days are harder than the others mentally, but I'm doing all right.
And Mr. Feigelson, have you had an opportunity to speak with her?
Yes, I have.
Do you believe she's oriented to date, time, and place despite not taking those mental health
I
meds?
believe she is, Your Honor.
And is there medication you're supposed to be on that you're not on?
No.
Are you taking your prenatal vitamins and all that? So you've also taken those?
They weren't, I didn't take them this morning. I was in a rush to get here.
What, you took them yesterday?
Yeah,
You took
every
them
day.
Today?
I've
Okay.
missed like one day this whole pregnancy, so
Okay, very good. And any sign of fever, COVID, or other illness?
no.
Are you up to date on your prenatal care?
Yes, ma'am.
Have you read the pre-sentence investigation report?
My attorney has read it to me.
And did you need more time with him or have you spent enough time with him?
I believe I've spent enough time.
All right. You pled no contest to count 1, assault with intent, 2, grave bodily harm less than murder or by strangulation. Do you recall that's punishable by 10 years?
Yes, ma'am.
All right. And the court should note that the probation department apparently did not read the plea agreement. But it's my understanding the plea agreement was no further upfront jail at the time of sentencing. She had already spent 121 days. And the probation department has recommended 28 months incarceration. So that needs to be, that will be changed. I take it there's no objection?
Do you approve?
No, you're
Not
right.
you, to the council.
Sorry.
Thank you.
No objection.
That was,
Yeah.
she hasn't violated, so there's no
No,
reason.
right.
All right, just making sure. Any corrections, additions, deletions other than that?
Not to the body, Your Honor.
Council?
Judge, I just have one or two minor changes to the body of the report, Your Honor. On page 3 and under the evaluation of plan, in the last paragraph, about the 6th line down, where the sentence that starts, the defendant recalled nearly 20 years of drug and alcohol abuse. It should be 11 years, Your Honor.
You said page 3?
Page 1, Your Honor, page 3 of the overall report, so.
Okay. I'm sorry.
In the last paragraph, it starts the
I got
defendant.
And from 20 to what?
11 years, Your Honor.
Okay, it's been changed to 11 years.
2 more changes. Her sister in the family section, her sister that's 23 Sierra, should be spelled C, or not C, excuse me, SIERRAH. Is that correct, Ms. Sager?
Can I double check?
Yeah, please.
I don't really have contact with my biological family, so. SE-ARAH.
Okay, let's start again.
E-ARAH.
Okay. So, this is a little strange. Do you have a stepfather?
I'm adopted.
Okay, so you have.
My biological mother is remarried, but I don't really claim that family.
Okay, but whether you claim it or not, I mean, adopted means you're part of that family. So you have your mother here, but I have a deceased father.
Correct.
Is that your biological father or your adopted father?
It's my adopted father that raised me.
And so who is Leonard Meyer?
Biological.
Okay, so I'm just gonna make a note, biological. Do you have contact with him?
No. Sorry, no, ma'am.
But you know who he is?
Correct.
Okay, and then adopted. Do you know who do you know who your biological mother was?
Yes.
Okay.
Jennifer Brown, Your Honor.
Okay. Do we want to add her or not? It doesn't really matter. Okay.
Judge, one more spelling rule.
Okay, just a minute. So
Sorry.
under, just to be clear for the record, under Mr. Sager, I put adoptive under father, and then under Meyer, I put biological, because it doesn't make sense to have two fathers.
Right.
That's why I asked about the stepfather, so now we're clear. Okay, and then I'm sorry, you had another name change?
Yes, Emily, instead of the Y, it should be IE, Your Honor.
E-M-I-L-E-E?
I-E.
Oh, I-E, okay, okay, got it.
And then one more change. On page 14, where it talks about the substance abuse treatment, Your Honor. She went to, is it Harbor
Village.
Harbor Village, Your Honor, and she went in October of 2007.
December.
Seventeen.
The day after my
Okay.
birthday.
Well, hold on. She went in, you said October of 2017, and then you said this one.
It was December of that year.
December of 2017?
Correct.
Completed treatment
Correct.
at,
Harbor Village, HARVOR, in Miami.
okay,
I have no other changes to the report, Your Honor.
any other corrections, additions, deletions, and on behalf of the people, are you in agreement with these changes?
With the body, I have no objection and no other additions or collections or deletions.
All right, as to scoring,
Yes, Your Honor, PRV 5 is currently scored at 10 points. PRV 5 is prior misdemeanor convictions. It is currently scored at 10 points. However, looking through the body of the report, it looks as though Ms. Sager has 5 prior misdemeanor convictions, so that would be 15 points instead of 10.
any objection?
No, Your Honor, I believe that's scored correctly.
5 is now 15, and is that the only change to the PRVs, because then the total would change to 15?
Correct, Your Honor, it does not change the level.
All right, how about the OBs?
No corrections to the OBs.
I believe the OBs are scored accurate, Your Honor.
Thank you. So changing the basic information sheet to reflect 15, so I think everything then is consistent. All right, very good. Do we have a victim here?
I've not had a chance to look yet, Your Honor. Is there a Mallory Hayner present? I can just check out in the hallway one moment, Your Honor. Your Honor, I just called her out in the hallway and she is not out in the hallway. I don't believe she's on Zoom, but I'm not sure.
All right, I was handed, I think this is our name for this case, a letter from Autumn Davis. Have you both received a copy?
Yes, Your Honor.
Yes, Your Honor.
Okay,
That's my client's sister. She's also present in the court with the rest of her family.
okay, thank you. And on behalf of the people, what would you like me to know?
Yes, Your Honor. Obviously, the sentencing guidelines to this case are 19 to 38. Obviously, there is an agreement to no upfront jail. However, I believe that there should be some probation in this matter. I would say an amount of 18 months. Ms. Sager appears to have issues with, seems to have had previous issues with substances, Your Honor. I understand that the end date is 2024, but people are concerned with that, especially considering this, in the situation this was occurred in being a party. Further, Your Honor, it sounds as if she has some mental health issues as well, so I believe that there should be some CMH requirements as well to make sure that those are addressed. So I would ask for that, Your Honor. Thank you.
Thank you. Counsel?
Yes, Your Honor, I do believe probation is appropriate for Ms. Sager, and ask that be what's ordered here today. She is willing to do what is necessary, Your Honor. She understands she made a poor choice back in New Year's Eve of 2024, Your Honor. She does recognizes the changes that she needs to make and has taken the opportunity over the last 13 months to get clean and get sober. And she realizes it's a lifelong journey that she's gonna have to continue to manage and monitor, and she can do that. She does have some issues with her mental health that she is working to address. I think the most important reason for her to get all these things in order is she's expecting to be her first child. I do believe that would be enough of motivation to help her get through this. She does live in Jackson, Your Honor. Her entire family is here. I'd asked the probation be transferred to Jackson. It might be easier for her to get the programming, because I know transportation and cost are difficult. She has to come up from Jackson to Lansing. Routine, I'd asked the probation be transferred to Jackson if possible. Thank you, Your Honor.
So ma'am, you told me that you were estranged from your family.
My biological family.
Okay. Your biological family,
Correct.
but your adopted family.
We're very close.
Okay.
My sister who wrote this letter, she's my biggest support. She's got 15 years clean and we're very close. And
Okay, very good.
And her adopted mother's here in the courtroom as well.
Okay, very good. So, what would you like me to know, Ann?
Well, first of all, I understand I made a mistake. I feel nothing but guilt and remorse. I have been clean for over a year. I've done everything that has been asked of me by this court. I understand they want me to do time, and I understand that, but if I do get time, I just ask two things.
You mean time in prison?
Prison or jail.
That was not the agreement,
Oh,
ma'am. So I told you up front, I'm going to abide by the agreement. However, if you use drugs or alcohol while you're pregnant, I will incarcerate you so that we have a healthy baby.
Right, I don't even smoke marijuana no more. It's out of my system. I'm trying to do everything right by you, myself, and my daughter.
Well, I'm just telling you, you're not getting it, but if you decide you have a bad day, I see it all the time. I get promises. If I had a penny for every promise that was made at that podium, I'd be retired 5 years ago.
I've already had some very horrible days. I've called my attorney crying. I talked to my support system.
Okay.
This is, I want this. I was addicted for 11 years. That's not the life I want to live. That's not what I want for my daughter.
And I'm glad to hear that, but understand, I want you to hear it and absorb it. I want your family to hear it. You do the wrong things. I do a couple of things. I incarcerate you for the safety of your baby and you, health, safety, and welfare of you and your baby. Jail's used to delivering babies and driving over to Sparrow, okay?
Yes, ma'am.
I will also call protective services and that baby will be removed from you and you'll be lucky if your family if it's placed with your family. So you've already gone through this as a child. You shouldn't have to put a child through it. So under my watch, I'm very strict on these things. And the state of Michigan is really unkind when we have a felon parent who chooses bad behavior instead of their child. So just understand, this is your moment to shine and really move forward with all the promises you've made to your family, yourself, and now this court.
Yes, ma'am.
Okay, and I'm gonna hold you to it.
I agree with you 100%. I was born addicted and I don't, so were my nephews. I don't want that for my child. I don't want her to ever have to see me like that either.
So are you working? What are you doing?
Right now, I go to my classes at the Women's Center and Children's Aid, Family Services and Children's Aid. I'm sorry.
So what classes are you doing?
Seeking safety. I don't remember all of them, but I go from 9 to noon on Tuesday, Wednesday, and Thursday. I meet with Miss Meredith there. They help me with accommodations, and it's people in recovery, mothers in recovery. It's not co-ed. We just sit there and we talk about what we're going through. I go to meetings.
So are you going to group and individual or just group?
Individual with a worker. I go to NA meetings at Home of New Vision.
Where was the place at?
Family Services and Children's Aid in Jackson on Michigan Ave. I've been doing my GED work. I am currently fighting for disability. I'm supposed to be going to court for that. With my scoliosis and being pregnant, I have already lost a few inches. I have severe scoliosis. I have worked before, but it's extremely hard. I do plan on, when I get disability, working part-time just so I can support my daughter. But
Let's talk about that for a minute. Who's the father? Do you know who the father is? Is he involved?
no, we don't speak.
Do you know where he is?
Yes.
Okay. And are you going to be going to family court for child support?
Probably not.
Why not? Did you have this baby alone? I haven't heard of no
I
such
mean,
thing.
I mean, I don't want to force him to be a father if he wants to be.
He just doesn't force him to be a father. It forces him to pay. It took two of you to have those 5 minutes of fun in bed, right? You got pregnant, right? There was no condom, right? And you had sex with a man you didn't plan to stay with, right?
Correct.
So he also has that responsibility. He could have chosen to wear a condom. He did not. And so he gets to pay for that. He doesn't have to be a dad, and if he doesn't pay or doesn't see the child, parental rights can be terminated if you want that, and that leaves the baby free to be adopted by hopefully a good man that you choose later on. But meanwhile, he gets to pay. You're gonna be on disability. Do you know how expensive babies are?
No.
Well, do you ever shop at Meijer's?
Yes.
Go down the baby aisle, look at the price of diapers and formula and bibs and onesies and all, and the shoes and all of that. Who's gonna pay for that? SSI, you think that's gonna be enough?
Probably not.
You're gonna go door to door and get donations?
Oh, sorry.
Well, have you thought of this? You're pregnant, ma'am, now's the time to think of it.
Okay.
You need a crib, you need a bouncy chair, you need an eye chair, you need the Gerber food or whatever you choose. I mean, come on. There's doctor bills. He is equally responsible to pay for that. And the law says even the birthing expenses. Do you think the people in the state of Michigan want to pick up his payments? Because you're going to apply for assistance. Right, as a taxpayer, I don't mind paying taxes. They're to help people like you, okay? But when we got a deadbeat dad, that doesn't sit well with me. Go to family court. You can ask for sole physical and sole legal custody. He's not involved. But guess what? He gets to pay.
See, I wasn't familiar with how all that works. This is my first child, and
I don't care if it's your first child, man. Once you engage in sex and have a child, you figure out the laws, the rights, and all of that, because your child, and now every time you sign the child up for benefits or see a doctor or go to school, you're gonna have to answer all these questions.
yes, ma'am.
Okay?
Yes, ma'am.
So it's as important as getting your GED and maybe some other degree. I don't know, whatever you're gonna do. He has a role in this. And even if his rights are terminated, guess what? And he might want to willfully terminate his rights. Great. He has to pay for that child until that child is adopted by someone else.
Okay.
Why are you letting him off the hook?
I just don't want to hurt myself or my child fighting for something.
How are you going to hurt yourself? You're going to have a lawyer, you can do it yourself, the judge is going to protect you. You have a right.
Okay.
The
like
child,
I said, I don't know
I'm
these
telling you,
things.
I can't give you legal advice, but I want to tell you that the child has a constitutionally protected right to child support, to receive all of the things afforded to him through both parents.
I understand.
That is your responsibility and the child's right. And as a taxpayer, on behalf of all taxpayers, it's offensive. You want to let them off the hook because we're going to pay. And I can tell you that the minute you ask for support from the state, the attorney general is going to come in, or the prosecutor is going to come in, somebody's going to come in and say, who's the daddy? And they're going to go after him for repayment.
Yes, ma'am.
So you're going to have a lot of things to pay for on probation, drug testing,
Yes, ma'am.
classes. He's not off the hook.
I understand.
Okay. Anything else from you?
With my probation possibly being transferred to Jackson County, is there any way my drug testing can be as well? We have the same-
Everything, it all goes together. We don't have you do here and there.
Thank you. That's it.
Anything else?
Not that I can think of. I did write an apology letter for her. I don't know if that can
You
be.
give that to probation and they'll transfer it to, and we'll need a copy to make sure it's appropriate, and then
Take a look.
we'll get you a copy. Brian, if you could get copies, and then probation should transmit it, or the crime victim should transmit it. We'll figure that out. Okay?
Yes,
I
ma'am.
appreciate you writing it. All right. All right, ma'am, you are going to be on probation for 12 months. I can increase it up to 36 months or 5 years if I want to, depends on how well or how poorly you are doing. And it sounds like from what your sister's written and from what your attorney and everyone has said, that you have some support and you're doing well, despite all of the problems you had growing up. So I'm going to look for that to continue. If you backslide, we may very well extend probation. I can put you in residential treatment. There's lots of things I can do. So it's totally up to you.
Yes, ma'am.
You're going to receive 365 days jail with credit for 121 days. The balance of the jail is held. I can use any or all of that time during probation if needed. I can also still send you to prison if needed. Hopefully, none of that is needed.
Yes, ma'am.
You shall not use, possess, consume, purchase, or be in the presence of alcohol, illegal drugs, or drug paraphernalia. If you need any medications, you will present a prescription from a licensed medical physician within 24 hours. And you will be tested at the frequency recommended by your treatment providers and probation. You'll not adulterate any tests. If there is a positive, you will pay for a secondary test to make sure it's positive and not a false positive. If you are in fact positive, then you'll be brought before this court. And certainly you can be on Zoom if you can't travel because of the pregnancy. And then we will look at immediate treatment, possibly residential.
Yes, ma'am.
You'll sign all necessary releases so we can verify that you're doing what you need to do. You will complete whatever treatment at the Women's Center you're going to that's required that you're participating in now. Show regular proof. What we care about is, are you attending? Are you participating? Showing up on time?
Yes.
Following the recommendations, okay? All of those become orders of this court. You will attend NAA, AA, or CA at the frequency recommended and regularly provide proof. You will obtain a sponsor. Or do you already have a sponsor?
No.
You will obtain a sponsor within 6 months, and that sponsor will have gotten clean and sober through a program so that they can help you. And I'm giving you that time so you find somebody, and you may already have somebody in mind since you've been going to NA who can be your sponsor. But they must be clean and sober through a program for at least 5 years.
Yes, ma'am.
You'll complete your GED, you'll follow through with your SSI. If you're not eligible, you will figure out some kind of work that you're able to do with your medical condition. You will apply for child support through the father of the child.
Yes,
So
ma'am.
you'll work with the family division to do that. You'll not engage in any assaultive, abusive, threatening, or intimidating behavior. You will not have verbal, written, electronic, or physical contact with anyone housed in the Michigan Department of Corrections without permission of probation, nor anyone who's on probation or parole. If they're in good status, you need to get permission. As long as everyone's in good status, then you can have permission.
As long as everyone is what?
In good status, then you can have permission to have that contact. Otherwise, you will not have that contact. You need our permission. You will comply with written and verbal orders of all treatment providers, including probation, and allow probation in your residence at any time for probation supervision without a warrant, and submit to a search of your person and property, including but not limited to your vehicle, residence, cell phone, and computer. If there's reasonable cause to believe you have items that might violate the condition of your probation, you will attend all prenatal care and all well baby visits. You will report any arrest or police contact, personal protection order placed on you, loss of employment, or obtaining SSI, etc., or change of residence and phone to probation within 24 hours. Weekends and holidays are accepted. So if something happens on Friday, tell us on Monday. Monday's holiday, tell us on Tuesday.
Yes,
I'm waiving probation oversight fees. You will pay $68 state costs and $130 crime victim, so that's a total of $198. That's going to be due January 1st of 2027. Yeah, I'll make it 2028. I don't know what your financial situation looks like. It's It'll be difficult. So you can start making a couple dollars every week or every month and get that paid off.
And
I've given you that extension so they don't extend probation for that purpose, because that's silly. And also so they don't attach additional fines and fees and whatever the state does.
where would I go to pay that?
And you'll send money here.
Okay,
So we'll keep track of that. So just send a check or whatever it is you.
do I address it to you or?
No, leave the clerks, you can talk to your attorney or go downstairs and talk with them about how to do that. I don't know if they accept Venmo or any of the other things. Money orders, hopefully you get them free. It's not worth paying a couple dollars for that, so maybe you wanna save it, do it all in one. I don't.
There might be an online system too, like.
There might be what?
An online system I can check.
Yeah.
I don't know enough about it.
Yeah, so they'll have information downstairs and just put your file number on it. If there's no restitution due, is that correct?
Correct,
All right. I've waived the probation oversight. You will not use any object as a weapon. You'll not own, possess, use, or be in the presence of any weapon, gun, imitation of a weapon. You'll not use any object as a weapon. You end up at someone's house and there is a contraband, you just do an about face and leave, and you will not have any contact with Mallory and Hayner.
Yes. Can I mention one thing?
Yes.
Another witness or whatever has been trying to reach out to me. I've got screenshots, but I have blocked them. I don't know why they would need to contact me. It's the person I believe she's living with. Just not understanding why they're trying to contact me.
Blocking them is a good idea. There's no, since you pled, there's not no contact with the witnesses that I'm aware of, but maybe, I don't know what she wants to tell you, but probably blocking is a good idea. Or if you have communication, have her refer to the prosecutor, the crime victims unit, or your attorney, and they can figure it out. But it's a good idea to block. That's a good decision. Yes, I support that. So she can always reach out if she needs something. She might just want to, on behalf of the victim, yell at you or something, and that's just stay clear of that. I don't want that to trigger you into something else. So you have 42 days to appeal and to request public counsel. Is there anything else I need to address that I didn't address?
That is probation able to get transferred.
Oh, yes, I'm sorry, yes. Probation can get transferred to Jackson. Here's the deal, if you violate, it comes before me, so you'll be back here.
Yes, ma'am.
The first meeting, though, so go downstairs, please direct her, the first meeting must be with us, because if you show up at Jackson, they're gonna say, who are you?
Okay.
So they have to meet with us, go over the orders, and they transfer. I've never had a transfer denied. So just go through the process. The first one's here, and if you can't do it in person, I'm sure they can meet with you on Zoom, just talk to them about the options, okay?
Yes.
But I did give her appellate form.
Okay, you acknowledge receiving your appellate rights? So if you're not happy with this, you have 42 days to appeal to request.
Yes, I understand.
Okay.
I wasn't sure what appellate was.
Yes, it just means you appeal my decision.
I understand. Thank you.
There was 121, I think I said.
Yeah.
365 with credit for was 121. And the balance is not. Thank you, that's all for this record.
I need it.
So I know we've got some other things, the court reporter needs a break. Probably everybody in the courtroom needs a break, so we're gonna take 2 minutes, thank you. 8, people of the state of Michigan versus John Joseph Magola. Both counsel are, or I should say, all counsel are present along with defendant. The jury came in about 5 minutes ago and said that, advised Mr. Ring that they have a verdict. Prior to entrance of the, or entrance of the jurors, let me just say that, I want to read in the questions for the record that we reviewed together, that came in at 9:15 this morning, January 28th. And juror 14, when was CPL expired? And the answer we all agreed to was the evidence is closed. Juror 6, are we to consider in any way the lack of reading of Miranda rights, or whether, are we to consider in any way the lack of reading of Miranda rights, or whether defendant was aware of the camera in the cab? We all agreed the answer would be no, or not to answer, actually. Second question was, if element 3 is not properly defined in instructions, could you elaborate? People's description felt vague and defense is highlighting different aspects. It seems so sorry if this isn't mine to ask. And all agreed that these questions would not be answered. Juror number 9 said, we would like video evidence and any other exhibits presented in testimony. The clean computer and all exhibits were provided at 9:15, and we all agreed to that. And then juror number 8 asked, was concealed, trouble reading the writing, was concealed carry law violated when the gun was placed and closed in the glove box? And we advised them to read jury instruction 11.1A and use your common sense and everyday experience. We all agreed to that. We also all agreed that Brian Ring, the law clerk, would read the answers to each question to them, and he did so. And then we did not have any further questions. They have been deliberating consistently until about 5 minutes ago. It's now 1:22, so the verdict came in about 1:15. We called counsel, everybody is present. And jurors are ready to come in. Is there any further record we need to make on behalf of people?
No, Your Honor, thank you.
No, Your Honor, thank you.
Thank you, the jurors.
All rise.
Thank you. You may be seated. As I advised when I read you the final instructions, when you returned, I would ask if the foreperson was chosen. So if the foreperson was chosen, please stand. Juror 10, you are the foreperson?
Yes.
Was the jury able to reach a verdict?
Yes.
Please read it in a nice loud voice into the record, please.
Defendant John Joseph Magula, not guilty.
On behalf of the people, would you like the jury polled?
Yes, please, Your Honor.
All right, you may be seated, sir. And as I explained before, I'm going to ask you each two questions. Was the verdict that was just read by the foreperson your individual decision? And was it the decision of the whole jury body? Juror 2, can you answer each question?
Yes and yes.
Juror 3,
Yes and yes.
Juror 4,
Yes and yes.
Juror 5,
Yes and yes.
Juror 6,
Yes, and yes.
Juror 7,
Yes, and yes.
Juror 8,
Yes and yes.
Juror 9,
Yes and yes.
Juror 10,
Yes, and yes.
Juror 12,
Yes and yes.
Juror 13,
Yes and yes.
Juror 14.
Yes and yes.
Thank you. The evidence will be returned. Sir, you are free to go. No more reporting to pretrial services. I don't recall what bond, if any, was posted. Depending on the type that would be returned to you or not, I simply don't know. You can talk to your lawyer about that. Anything else we need to make for the record?
No, Your Honor, thank you.
No, Your Honor, thank you.
Sir, any questions? Free to go.
Yeah, thank you.
Thank you. All right, that is all for the record. And for those of you waiting to appear in front of me, you're gonna have to wait about 15 minutes longer. Counsel and I are going to join the jury to personally thank them for a couple of minutes.
All right.
Counsel, would you like to join me?
Romero, can you mute it, please? Yep, thank you.
through all these, what about all these, final criminal
Oh,
trials?
we're gonna be doing those as well. I just wanted to get Mr.
Okay.
Wells in and out.
All right, very good. Motion is set aside. Sorry for your wait, sir. All right, and are you from her?
Huh?
Are you representing yourself?
Yes.
All right,
Yes,
very good.
ma'am.
That file on top for, that paper's on top for the case.
All right. This is docket 91-63330FH. Counsel, your appearance for the record.
Good afternoon, Your Honor. APA Burt Fluxon on behalf of the people of the state of Michigan.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yep.
Thank you. Put your hand down. On behalf of the people, I see, I think I have all the paperwork. Do you, and are the people opposed or not?
So, Your Honor, the people now have all the paperwork. I don't believe Mr. Wells gave that paperwork to our office, so I had to get it online on Monday. Unfortunately, under the Victims' Rights statute, our office does need to provide the victim notice of these statutes, and because of us not getting the paperwork and me only living in the system until Monday, I would need some additional time in order to comply with the statute.
How much time do you need?
I believe 2 weeks should be sufficient, Your Honor.
Well, let me ask you this, since he's here and waited all day, what if we do this tentatively, see if she has any objection, bring him back if there's an objection, and if not, sign it?
I'm fine with that, Your Honor.
Okay, does that make sense to you, sir?
I didn't know what it meant you guys are talking about right there. I got lost in the
Oh,
first
all
round.
right, all right. So, sir, there is a Crime Victims' Rights Act.
All right.
And under that act, the victim has the right to receive notice of all hearings and proceedings related to the crime. Okay,
All right.
so this is, the charge was reckless discharge of a weapon and there was a victim involved.
Right.
Okay, so he or she needs to be noticed of the hearing, and they were not. So, I know you waited all day. So I'm going to do a little, well, it's just a legal fiction. I'm going to pretend that you're here 2 weeks from now. Here's what we're going to do. The prosecutor is going to notify the victim. If the victim has a problem, we will call you back in 2 weeks so that I can make a decision after I hear from her. Today, I am going to make the record, and if she's okay with, or they can't reach her for whatever reason, then we're just gonna let it, then it's just fine, it's gonna enter.
All right.
Does that make sense to you?
Yes.
Questions?
Well, the lady, the one you're talking about, that'd be my sister Meryl.
Oh,
And she ain't quite all there right now.
okay.
And she was at the courtroom and everything, helped me out, and physical probation and everything. But
And that's perfectly
I don't
fine.
know how to really put it to you.
It doesn't matter, sir, because I'm gonna grant it today. As soon as the people let me know that she's been notified and whether or not she's with it all, or as long as they provide her notice, that's up to her and whoever her guardian or whatever is. If she's okay with it, it's just gonna enter. If she's not okay with it, it sounds like she will be okay with it. If this is just gonna enter, you don't have to come back. Is that okay with you?
Yeah, only, well, I like to get it done because I like a little deer hunting.
I get it, sir, but,
That
there's a lot
kind
of.
of bummer when you're sitting in your room and just looking out a window and looking at a couple good sized bucks run
Well,
across
you need to find a
47
couple,
acres.
yeah, you need to find a couple of good movies for a couple weeks, but, you waited since 1991. I think 2 weeks is good for you to wait.
All right,
There's nothing, I can't override, what the legislature has done with the Crime Victims' Rights Act, so I can't do that. But I am going to make it convenient for you, okay? And so we'll send you a signed copy in the mail, and my law clerk can even call you, or the, Crime Victims Unit can call, we'll get your number, and we'll call you and let you know, okay, as soon as she's notified and
is
everything's
it
clear.
okay? I got my helper back there. Right there, he got his phone.
Okay, did you understand everything, sir?
Yes.
All right, and sir, can you can hear fine, or do you need, we have a device that helps?
No, I hear fine.
Okay.
I hear real good.
Okay, very good, that's good.
I can hear a chipmunk run across the field.
Well, that'll be good for your hunting. All right. All right, so on behalf of the people, aside from that, once you notify the victim, if there's no objection, or if she's non-responsive, is there any objection on behalf of the people?
Your Honor, I have had a chance to look at the letter from the Attorney General. The Attorney General believes that he is eligible under the statute. As long as the victim is okay, and as long as the circumstances and behavior warrant the setting aside, the people would have no objection.
Thank you. Sir,
I'm sorry.
what have you learned from all of this since 1991? I don't need to know everything you've done. I'm sure you've done quite a lot.
No,
But what have you learned from
I
this?
ain't gonna beat around the bush. Number one, next time I'm in Lansing and I see somebody shooting a shotgun, they're on their own. All I was doing is trying to help the cops, that's all. I didn't want I had a girlfriend in right over there by Fitzgerald Park. And what I was doing, staying with her, but his name was Paul Spence, was shooting a shotgun. And he was aiming that way, and I didn't want nobody to get shot. So I went over there and grabbed it. I guess you learn the hard way. You'll never do it again.
Well, that's unfortunate, sir, but some ways, some woman is gonna get you in trouble, so you learned your lesson in multiple ways, I guess.
Oh, I learned it in every way. I grew up, I learn a lot faster now.
I agree with that, me too. All right, an application to set aside the following conviction was filed on October 20th, 2025. Reckless discharge of a weapon, the date of conviction was March 3rd, 1995. Michigan State Police has reported the required information from its records to the court. The applicant has not been convicted of more than 3 felonies. The applicant has had no convictions for an assault crime set aside pursuant to the statute during their lifetime. There are no criminal charges pending against the applicant, and the applicant has not been convicted of any criminal offense during the applicable time period required under the statute. The applicant has not previously had a felony conviction for the same offense set aside pursuant to the statute, and the time period required by the statute for the conviction listed in item 1 has passed several times.
Oh, yeah.
And an opportunity has been given to the Michigan State Police, the Attorney General, and prosecuting official to contest the application. Circumstances and behavior of the applicant from the date of the applicant's conviction to the filing of the application more than warrant and justify setting aside the conviction, and it is consistent with public welfare. Therefore, the application is granted once the crime victim is notified, and that is as to the conviction listed in item 1. And pursuant to the statute, the Michigan State Police shall maintain a non-public record of the order setting aside conviction and of the arrest, fingerprints, conviction, and sentence of the applicant in the case to which this order applies. If the court or arresting agency maintains a record of the arrest biometric data conviction or sentence, that record shall be non-public and not used for any purpose unless authorized by law. This has been signed and read in open court. It will be dated the day that I am notified that the victim was notified, and then we will forward it to you, and my clerk will enter it immediately, and it will be forwarded to the agencies. If you find in a few weeks that it has not been entered, please call me so I can call the agencies and let them know they better enter it, okay?
All right, what entry I call over here or?
You would call our office and then we'll.
Or like way downstairs like we did before?
No, please approach, sir.
All right.
Here's the phone number of the office. There's even a Zoom number if you want to zoom in and see everybody else acting bad. Congratulations, sir.
Thank you. Have a nice day.
You too. We'll get you this soon, okay?
All right.
Thank you. That is all of the record.
Thank you, Your Honor.
I'm sorry, do I leave, can I?
What is
leave this?
that?
This is a bunch of them papers.
You keep them. We got all the papers we need. We're good. Just keep
Okay,
them
I
with
didn't
you.
know you was a hammer.
Yeah, thank you.
We're gonna do Travis Arnett Brain next. Travis Arnett Brain, yes.
I'm just not finding it.
Set at 9 o'clock.
All right, sir, I'm sorry, you've been waiting all day. All right. This is docket 254344FH and 254348FH, People of the State of Michigan versus Travis Arnett, is it Brain?
Brian, yes.
Okay, thank you. Counsel, your appearances for the record.
Good afternoon, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
And good afternoon, Your Honor. Dustin Kuntz for Travis Arnett Brain, who's here to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth and the penalty of perjury?
Yes, Your Honor.
You put your hand down. Have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
Have you had enough time to speak with your attorney?
Yes, ma'am.
And this is a final pretrial conference, is that correct?
That is correct, Your Honor.
And what was the offer, if any, on behalf of the people?
Yes, Your Honor. There was an original plea offer given in this case at the time of district court to a plea of count 1 as well as count 8. Count 1 is the delivery manufacturing of cocaine, heroin, or other narcotic, 50 to 449 grams. And count 8 is the felonious assault, and then the remaining counts, as well as the habitual offender status, would be dismissed. I am aware that Attorney Kuntz has contacted John Dwayne for an additional offer. There was an alternative plea offer given to count 1 as well. And then counts.
And what about the
3.
254348 file?
And that case would be dismissed in its entirety, Your Honor.
Okay, so what's the second? So I got the first offer. What's the alternative offer?
So the alternative offer, if the defendant did not wish to plead to the felonious assault, would be a plea to count 1, a plea to count 3, which is a possession of a firearm by a prohibited person, and then count, I believe it's 9, the felony firearm, or it would be count 11, Your Honor. The felony firearm in regards to the possession of a firearm by a prohibited person, and dismiss the remaining counts. My understanding is that at this point, the defense does not wish to accept either offer, and plans on filing motions in this matter.
Counsel?
That's more or less right, Your Honor. We waived prelim on both of these files with the idea that the original offer would remain on the table, but that I could continue to negotiate to see if we could do something better. The second offer was, in my view, worse.
I would agree with that. Because, and for the record, that's because the count 11 is 2 years consecutively within proceedings, so.
And that would be correct, Your Honor, and my understanding, obviously I am not Mr. Dwayne, but my understanding is because we would be dropping the victim charge, we would instead be doing that instead.
Okay.
But Mr. Buxton's correct. I think at this time, we would actually request another final pretrial. I know this court is trying to move cases. We've only had one pretrial in this matter in circuit court since it's been pending. And even that day, I think there was I forget who was assigned to the court at this time. Maybe it was Mr. Buxton, but there was a fill-in prosecutor that day. So we filled out the form, we got out of here, we got a final pretrial date, but this is only the second time we've appeared in circuit court on these matters. I want to look into filing a motion to suppress, have a subsequent final free trial.
These are 25 cases. What's the trial date? Do we have one?
The trial date currently, Your Honor, is March 6th.
Okay. Here's what I'm gonna do. This March 6th it's not gonna go. I'm sure I've got a whole bunch of other trials. So here's what we're gonna do. I don't know if I'm in criminal or civil, but here's what we're gonna do. We're going to have a trial date of September 4th. We are going to have a final pretrial. August 19th. That's plenty of time. Don't ask me to move it. In between now and then, if you end up with a plea situation, please set it for a plea, and then we'll remove the final pretrial and trial.
Okay, and then just contact your staff for a motion date, is that right?
That's
Okay.
exactly right. So then you've got time for your motions and a final, which is not going to be moved, and plenty of time to, and by that time, this is gonna be an old case and we move right up the ladder. So I'm not gonna pull around and say, oh yeah, it's a 25 case, you're gonna go to trial in 6 weeks, because it's not. So by the dates I've given you, it's more
than enough. Thank you, Your Honor.
bond conditions are continued, sir.
Yes, ma'am.
So keep checking in with pretrial services, and you must be doing the right things, because this is the slimmest file. It almost feels empty. So just keep doing the right thing. Stay in contact with your attorney. Keep your address current. Is your address on Woodbine?
No, ma'am.
Okay. Is that the address I've been both? Okay. What is your? Have you given it to pretrial services?
Yes.
Okay. So they have it. What is your current address?
5527 South Washington.
Okay. And who lives with you?
It's me and my wife.
Okay. All right, sir. So just keep doing the right things, and we'll see you one way or the other and get this resolved, okay?
Yes, ma'am.
That's all. Thank you, Your Honor.
Thank you. That's all for the record. Next.
Your Honor, at this point, we'll do Clifford Sleeper.
Oh, it's already down. I got it. I remember that. Okay. This is it. 252982 FH, People of the State of Michigan versus Clifford J. Sleeper. Counsel, your appearances for the record.
Good afternoon, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Good afternoon, Your Honor. Equity and everyone, you can Mr. Sleeper, Mr. Counsel Paper.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, it is.
Thank you. Put your hand down. So I am baffled as to why we're here and why we're wasting time on my docket. And so I need some clarification from either counsel. I sentenced defendant August 27th of 2025. I sentenced him to more than what he was, more than the kilogram.
That is correct, Your Honor. There was a Killebrew to a stipulated sentence of 12 months to 60 months. And it looks as if, based off of my notes, I was not the individual there. It looks like you had sentenced him to 40 to 60 months. So my understanding is that his plea was withdrawn at that time. I will state, I do have notes in here that it sounded as if the defendant did want to reaffirm his plea and accept the sentence.
Yes.
I am not sure if that is still the case or not, but.
So, he was. And I had updated here, I think so.
So after that date, Your Honor.
He pled, and was this, I don't remember if this was a jury trial.
He pled in district court, Your Honor.
Okay, so he pled to 6 counts of criminal sexual conduct, 3rd degree, person 13 through 15, and each was punishable by 15 years, is that right?
No, Your Honor. That was the previous conviction.
Huh?
That was the previous convictions.
Oh, okay. Oh, okay, I got it.
Ag stalking.
I don't have, oh, I'm sorry, okay. I'm looking at the wrong thing here. This wasn't when I didn't do the plea, so I'm looking at. All right, so he pled, I got it to count 1, aggravated stalking. And that's punishable by 5 years. And based on the circumstances, there had been a Killebrew to fit 12 months to 60 months. I gave him 40 to 60 months after reading this and hearing everything. And so, Ms. Wanji, you had said we will appeal. We want to withdraw the plea. And then we were set to do that. And the next day, my understanding is that defendant contacted our office. I didn't talk to him. But Brian Ring, my law clerk, did, and he said, I don't want to withdraw, I just want to do it. So that's how we ended it. So what are we doing here now?
My client contacted the court without my advice. I didn't know. I received an email from Brian stating that my client called the court and said that he wants to proceed with the sentencing.
Well, it ultimately is his decision, isn't it?
Yes, Your Honor, it is his decision. However, we had said with the prosecutor, we thought that we will set it for a pretrial so that he puts that on the record, because when I went and talked to him, that was not what he was planning to do. And we've been waiting to put that on the record.
Okay, well, let's put it on the record now. Sir, what would you like to do? Did you want to withdraw your plea?
The plea deal that was offered is not available, then yes, I would like to withdraw that plea.
So what prompted you to call our office and say you didn't want to do that?
I was under the notion that prior to coming in here on 6/27 for the sentencing of the plea deal of 12 to 16 months, that you and my defense attorney and the prosecutor had met in your chambers and you agreed to this. And when I left here with my soul ripped out of me. After serving already 12 years in prison and also serving another 12 months for the technical parole violation pertaining to this same date and issues.
Well, the technical parole, you got no credit for. That's because that's the rules of parole. You understand that? So.
To answer your question, I called out of fear and misunderstanding. I couldn't get a hold of Miss Wanji, my defense attorney. I kept trying several times. Her addresses have changed. The phone numbers were given to me were not current. And the counselor at the housing unit, Mr. Hoffman at the MDOCSU, said you can call the judge, and gave me a piece of paper with their number on it that he looked up on the internet.
All right. You certainly can withdraw your plea, given the circumstance. And then this will go to the pretrial stage.
You know, because my client had pled at the district court level, and he the reason why he pled in circuit court, in district court, is because he relied on the the agreement,
He relied on the what?
on the plea of agreement.
On the plea agreement, yeah.
We waive the preliminary exam. Because of that, it was, if you don't do the preliminary exam, on the plea will be withdrawn if you don't do the preliminary exam. So at this time, we would ask the court.
What
to send-
prosecutor said that? That's unconscionable.
Maybe we should ask Mr. Baston next time that the office doesn't give us this kind of deal, but that was last. If he had said done the preliminary exam, we have that a lot. If you do the preliminary exam, the plea is of the.
So what is your request, counsel? Is it that you go back to the preliminary exam?
Yes, Your Honor.
Counsel, response?
Your Honor, unfortunately, I do not have a transcript of the preliminary examination, so.
There was not one.
I understand, but the day before the preliminary examination at the time of plea, so I am unsure if that waiver of the preliminary exam was conditional on the plea or unconditional. So I do not have that at this point. Your Honor, the concern is, part of the reason why we are here today is the defense has filed a motion to dismiss for the 180-day rule.
Well, I'm not granting that. You guys can make your record. I'm not granting that. I'm just not, especially under these circumstances. I'm just not, I've been here. I've rarely taken vacation. I don't know why you're all not in front of me. You can make your record. I'm not granting it.
And
I've looked at the file.
I understand and I would agree with that decision, Your Honor. The concern is if this case gets sent to preliminary examination, there is a potential issue with the 180-day rule unless he is at this point waiving the 180-day rule to go back down to district court for preliminary examination.
Are you waiving it to go down to preliminary exam?
I don't think that the court can ask him to waive it because you can say that some of the
Well, then here's what we do, counsel. We'll have an evidentiary hearing here instead of a preliminary examination, and then we'll proceed from that. How's that? There are multiple ways to get at the same answer.
we can do that, Your Honor.
I need you to go back today and get a date. And I don't know if this is gonna take a half a day, but you need to get on my docket for that.
Will do, Your Honor.
Will do, Your Honor.
So let me ask you this. Is he in the Michigan Department of Corrections solely on mine, or was there another sentence he was also serving?
You know, the fact that he's set to be paroled in few weeks. This case is the one holding the parole board.
Well, maybe it won't now, given this, I don't know. Because I just withdrawn his plea, and we're gonna have an evidentiary hearing.
Yes, Your Honor, but you can, I know that you already ruled that you're not going to grant the motion. But there is some prejudice here for my client, because had he been sentenced on time, he would be getting credit for the day of the sentencing. But since the
year wouldn't be up. The year wouldn't be up.
What did you say?
I said the year wouldn't be up, would it? Because he was sentenced.
He had a year on his parole violation, and the year is gonna go on. It's gonna be.
But on my sentence.
He's been paroled on March 23rd.
Okay, but I sentenced him on August 27th, 2025.
Yes,
And so the plea agreement was for
a year.
Yeah, 12 months. So
12 months.
he hasn't done the year of my year.
Well, we hasn't even started. He haven't even started yet, and because of that, he's been prejudiced. The whole board is not going to let him. He's not going to be paroled because this case is still holding the decision, and he's going to be maxed out in 2 years on the previous case.
Well, we're going to get to this as quick as we can. And the bottom line is, when you're on parole, don't commit another offense.
He's still presumed innocent until proven guilty.
Okay, and we can play that game. That's true, except he's already pled. We went through all this. I have a PSIR. And so from that aspect, that's where my comment comes from. And yes, now he's presumed innocent until proven guilty beyond a reasonable doubt. You can have a jury trial and we can hold him in lockup.
We're gonna get a new date, yeah.
Great, get a date. Let's just hasten things so we can get all this sorted out, because every which way I see this, I'm not releasing him. So he can go on bond, and at no bond to jail. Parole board is gonna be happy with that. So let's just get to what we need to get to. How's that? And we can clear half a day and get where we need to. How's that?
Understood, thank you, Your Honor.
Great. Please go back and get a date.
So I was here on the 27th. When was he? So that's why you may have.
Probably we need to have, so she withdrew it, he withdrew it. The next day we need to modify it to say defendant.
So he is technically sentenced on.
He was sentenced on it, but the next day should reflect something. You need to work.
Yeah, I can make a amendment, but I have to backtrack.
Yeah, you need to backtrack it.
But I have to email the date. Okay, so I emailed immediately.
I was saying, because it's still, that's another case of.
Yeah.
Why?
sure, yeah. All right, what's next?
I don't have any more criminal defense attorneys, Your Honor, so I guess you can move forward to the civil docket at this point.
I think the civil attorneys would appreciate that. What is this? We know what we're doing next. This is what we can.
Yeah.
Okay, who's on the civil docket? Or what's?
The settlement. Settlement conference on.
So.
So that doesn't go on the record?
Correct. You go on the record ones real quick.
You do, I just don't have any attorneys.
What's the name of it?
Peachtree.
Peachtree, okay. Is this the one that didn't show up?
Yeah, they're both here.
All right, this is docket 25-6, anybody, Nancy? Yes, 25-6217 CZ. In-rate transfer of structured settlement proceeds to Peachtree Settlement Funding LLC. Counsel, your appearance.
Good afternoon, Your Honor. For the record, Joel Grand, P51261, on behalf of petitioner Peachtree Settlement Funding LLC.
All right, and you are the payee?
Yes.
And what is your name, sir?
Claude McCullough.
Could you spell that for the record?
CLA.
Judge, there's people talking, I can't hear.
I need everybody, if you're going to talk, please exit the courtroom.
Sorry.
CLAUDE. Last name MCCOLLUM.
All right, thank you. And what is it's my understanding, sir, you received a settlement for a personal injury action, and now you want some of that money now instead of as you're getting it, you are getting, what, $250 a month, right? Okay, and so, counsel, what is the offer?
Your Honor, my client is proposing to purchase $250 per month out of the $2,000 he's currently receiving per month. Specifically 175 payments of $250 beginning March 30th, 2026, ending on September 30th, 2040, in exchange for which my client is prepared to pay Mr. McCollum $14,285.13, which is a interest rate equivalent of a 20.18% per annum transaction
Per annum, you said?
per annum.
Sorry, they're still talking.
All right. Sir, why do you need $14,000?
To find, a place to stay.
Okay. You're giving up 75% of your $2,000.
Yes.
Okay, so have you done the math on this? So $1,775, is that right, what it is?
Your Honor, he is currently receiving a total of $2,000 per month. He's proposing to sell out of that $250, so he will still have $1,750
Oh,
coming from the annuity
okay, I
to
have that.
him during the time period of the sale.
Okay, so he gets 1,725 or 50, $1,750.
Correct. It's my understanding that he will still have $1,750 per month.
And how much money are you taking for this?
Your Honor, the aggregate nominal total of the payments being purchased is $43,750. And my client prepared to pay Mr. McCollum $14,285.13 in exchange for the right to receive those future payments.
Sir, what options have you looked at? Because there are other options where you could get some assistance and not pay triple. I mean, $43,000 you're losing.
Other options that I've looked at is food assistance
Where are you living now?
across the street, the shelter.
Okay, and is there no other option for you to live with someone or, I mean, this is a lot of money. This 43,000 could probably buy you one of these homes down here. And you're giving that up. And you have $2,000 a month. Where's that money going?
So that, I don't know if this answers your question or not, but like I said, the food stamps, the 2,000 is, like you said, it's wrongful conviction income, food assistance there, it's a bunch of issues.
I want to make sure I understand this. It's been a long day. You received every month $2,000?
Correct.
So let me just understand. So you are going to give up $250 of that. Okay. Is there a room that you can rent for $250 a month in someone's home until you can save up enough to get a place? I mean, this seems to me not a financially smart move. You're getting $2,000 a month. Most of the homeless people I know are getting nothing. So where is your $2,000 going? What are you spending it on?
Okay, so I do have I have a vehicle
Okay.
that requires upkeep.
Okay. Do you have a payment on that?
No.
Okay, so what else are you paying the $2,000?
I'm homeless, but I did have a home. When I sold my home, everything I had to put into storage.
Okay,
So I have a couple of storages.
so how much is the storage?
One of them is 190, the other one is 160.
Okay, so that's $350. What's happening to the rest of the money?
Well, like I said, the vehicles upkeep.
Are you telling me that, I mean, I have a rather new vehicle. I'm not making that much of a payment on it. Are you telling me that you're putting into your vehicle $1,700 a month?
So I just recently left the dealership yesterday. There's 3 recalls on it. 2 of the recalls, they don't have a solution for. The other recall is possibly having to
give me a new battery, but there's issues that
But
I'm.
the recalls don't cost you any money, sir, and they should, if it's their fault, give you a loaner. And if it's a lemon, the Attorney General has an office that can help you with that. So again, what are you spending $1,700 on a month?
So when I went in yesterday to the dealership, I asked about the loaner. They were pretty much shying me away from that. But
What other bills do you have, sir?
so last week I got stranded because of car issues, and that was expensive. I had to get a hotel. I had to call a family member when I got the bill from them. But yeah.
Sir, again, you're not answering my question. I'm trying to figure this out. Because I have to find, I don't, if this isn't in your best interest, I'm not helping you out. I'll tell you what to do though. There's lots of options I don't know that you've considered. These people, no offense to you, counsel, but this is usury. There are other options and they take advantage of people who feel like they have no other options. And that's their business and I don't fault them for that. This is America. And you have choices and so do they. And that's, you know, in your lowest point, they're there to rescue you. They can rescue you. But I want to know what other options you've considered and where the rest of this money is going. Because you're going to get $14,000 and that money is going to go away really quickly. It's not going to pull you out of poverty. It's not going to pull you out of homelessness. So, sir, do you have credit card debt? Do you have other debt? Where's the money going? Do you have an addiction? What is the issue? Do you have a gambling addiction? What's the problem here, sir?
I do have to.
What kind of debt?
I have a cell phone.
Okay. What else? Do you have credit card debt, other debt?
Credit cards, yes. My financial institution, they've been doing a courtesy pay, and then
What does that mean?
that means that they pay my bills if the money isn't in there. And
So
then,
how much do you owe them?
so I owe them like 1,000 to 1,200.
Okay, you can pay that in 1 month or 2 months or whatever. Okay, what else? I'm still not understanding where $1,700 is going per month. Even if I look at food, I suspect you're not spending, you know, you're not going to glamorous restaurants. So let's say you're spending $20 a day on food. I don't know, what is going on?
Well, to answer your previous question, and no offense to the attorney, but another option is for me to come in here myself, file motions, represent myself, so I won't be getting slapped in the face with the fees that they charge.
What fees that who charges?
Well, I know at one point I thought I heard you mention that they're charging a lot in for the amount.
$43,750 is what you're losing in order to get 14,000.
So if I came in here, filed motions and represented myself.
No difference, sir. I mean, I don't know. I guess it's possible. I don't know what you want to file to get. What do you want to file? To get more money? To get an advance?
Yeah, I'm going through a hardship right now. The money that I'm getting.
Okay, let me just say this to you, sir. I don't know what conditions you are getting this money on. I don't know if you can take a loan out against yourself, and that may be an option, and you can talk to the provider, whoever's giving you this money. I don't know. I can't give you legal advice, but I can tell you should look at the document with legal aid. The other option is, if you have a lot of debt, is to file bankruptcy. Bankruptcy is not going to cost you $43,000, and then you'll be debt free. And then the Attorney General's office, which legal aid can help you with, if somebody who's servicing a car is not honoring the warranties or a car for you to drive, and there are 3 recalls and they have no solution, which means they're taking away your car, that may very well, and I haven't read it in several years, the Lemon Law is in place. I do not know if that applies or not, but you have not explored those options, and you're getting $2,000 a month. you're going to be getting less. You're gonna have a one-time 14,000, that's gonna go, it's gonna be like water, it's gonna go away. And then you're getting $250 less, which is going to put you further in the hole. So sir, I'm gonna set this out another month and you explore your options, because the answer to this is it's not in your best interest. You have a lot of other options. The answer to this is no. You can refile it. This is no without prejudice. You can file a motion for reconsideration, but sir, I want you to go look at your options. Legal aid, the State Bar of Michigan, if you call them, they can assign you an attorney. Talk to a bankruptcy attorney, talk to a financial planner, they can help you with this. And no offense, counsel, your boss is in it to make money. I don't begrudge them making money, but this is not in his best interest. I wouldn't make this deal, and I don't think you would either. So for today, without having these other answers, so that I can be assured that this isn't like going down the sink really quickly and then you're coming back again, because I have had people come back 2, 3, and 4 times and give away their whole settlement, and then they got nothing. And then you're really on the streets. So sir, you got $2,000, write down where it's going. Look at where you can cut costs. Meet with an attorney or financial planner. It's free to meet with most financial planners. Your bank might even have a financial planner. Look at where your money's going. And then we'll talk about it again. So this is not with prejudice, but I am denying it for today for those reasons.
So, Your Honor, are you denying the petition, or are you pushing it out for a month to explore the options?
I'm denying it for today. I'll give you a date in a month or so, and then he can, but I want him to have explored those options, and then you don't have to refile it, and it'll save some time, but sir, you've got to meet with a financial planner. Your bank has one, I'm sure, that you can refer to. They're free. Did you know that?
I just left my bank a couple days ago. I went in to use my vehicle as collateral. They denied me.
Well, because your vehicle right now is worth 0, it's not even working. But the Attorney General has an office that may very well help you. 3 recalls without a resolution, that's unacceptable. And I bet the Attorney General would agree with that. And it doesn't cost you anything to go to the Attorney General. It's a phone call and a little bit of paperwork. Did you know that?
I'll highly consider that.
Car dealerships cannot take advantage of us. And I want to make sure that you understand your rights before I grant this, okay? Because this is a lot of money you're giving up, okay? And they're not representing you. This attorney is not representing you. He's representing his boss or his company. And you're representing yourself, and you're not fully informed. And I want you to be fully informed and look into your future without this extra $250 a month that you've gotten used to. This 14,000 is not getting you out of trouble. So it may seem harsh to you, but I am truly doing this in your best interest. I want this to be a fully informed decision. And counsel is not, he doesn't represent you, so it's not, he's giving you what they consider a good deal, but he's not looking in your best interest. You need to look at your best interest. Okay.
Okay.
Okay. So I'm going to give you March 11th at 1 o'clock. It's a little bit longer, but I've got a month-long trial, and I don't know. I'm going to try March 11th at 1 o'clock. All right.
March 11th at 1 o'clock would be great, Your Honor.
Great, thank you, counsel. So, and I've stated that correctly, sir. You're not his attorney.
No, I'm not. It's very clear. I'm not his attorney. I represent Peachtree Settlement Fund. As I put on the record, my client had recommended to him in writing, when he received all the paperwork, that he should consult with an attorney or financial planner of his own. He chose not to do so at that time.
Yeah, and he hasn't done that, and so I want you to be fully informed. I want you to take care of yourself, sir, that they're not taking care of you. This is a one-sided deal. Okay.
Thank you, Your
Just
Honor.
reach out and get some help. I'll see you in March. Thank you.
Should I send out a renotice of hearing on this, or?
That'd be great, thank you. And then if it does settle or whatever, let me know if he goes a different route. Otherwise, I'll see you then. Thank you.
Thank you.
We have this other subdivision real quick.
What is it?
It should be the Welsh, Stonehouse and Welsh.
This is Stonehouse Village, the fourth LLC versus a number of Welsh properties, docket 254905CH. This is ex parte motion for confirmation of service and in the alternative extension of service and directions for alternative service.
If necessary, I guess.
All right, so sir, what's going on in terms of the service?
May it please the court, Your Honor, William B. Tomlin on behalf of Stonehouse 4 LLC.
It's been a heck of a day, sir. Yeah.
May it please the court, Your Honor, William B. Tomlin on behalf of Stonehouse Village 4 LLC. The court did extend the service by prior order. I believe I have appropriately served the entities.
I do have, I want you to know, and for the record, I just want to say, because you're correct, and I want to say I do have, and you did provide, thankfully, so I don't have to look it up, a number of exhibits that do show the service by the return receipt. So I don't know. On one of them, I see it received, it says printed name, it doesn't have the signed one, but maybe that was cut off. And then another one, it does say, it does have two signatures. Well, it has a signature by Greg Rogers, looks like printed and signed.
Yes.
So how can I help you?
Well, Your Honor, as my pleadings indicate, that this was a matter of quiet title. This property was sold back in 1990. There was a right of first refusal.
It's sold by what?
Sorry.
No, slow down.
Yeah, this property was sold back in about 1990 to my client. It had a right of first refusal. It had some deed restrictions on it. My client is interested in potentially looking at marketing the property. It would impinge the title with the right of first refusal. None of these entities appear to be extant anymore.
They look like they're all defunct. I don't know how you get them served.
Well, luckily, under Delaware law, because they named a registered agent before they went out of business, that registered agent stays in place unless changed.
Okay.
And I cited the case law to that, Your Honor. It's, I believe it's 8 Delaware Code, sections 30.
Yes.
Yeah, there it's.
Yeah, you did a lot. You cited a lot of cases. Yeah.
Yes. And there's additional case law which I cited indicating that if there's a voluntary appointment of an agent, even if the defendant loses contact with that agent, the service on the agent is valid. I just asked the court to confirm the service that I have satisfied the constitutional and statutory requirements for service, make those findings, because I'll probably have to record this with the county recorder to clear the title at the time of the sale. So I have a somewhat of a robust order that I'd like to approach the court with.
Okay, thank you. You may approach.
Thank you.
I can clock how fast you go. You're today's winner.
What is it, Nancy?
336.
336.
All right, the person who acknowledged receipt, which was said a couple of minutes ago, was that signed attachment.
Yes, I
I
have.
take it, the Greg Rogers, and that was signed on November 2nd. That must be 25, so.
Yes, Your Honor. One of those, I'm required to serve both the corporation as well as the Corporations Bureau here in the state of Michigan. One of those is the Corporations Bureau of the state of Michigan, and the other one is the registered agent in Delaware, which is National Registered Agents and I served them at their stated legal address.
And they signed it, well, by stamp, I guess maybe that's weird that they didn't use a signature, maybe that's their, what they do, but they do have, two different type styles, and maybe they do that on purpose, but, that was done on October 24th, 2025. So it does look like you have complied with the rules, the laws, and, everyone has had proper notice, and you should be given the title. The court has reviewed this. There's no one here to object. And court is signing the order. It does find that the defendants voluntarily named the Delaware registered agent in accordance with the law. There's been no steps. The court has heard nothing. My file is really empty in terms of any defendant responding or otherwise defending or pleading. Therefore, you will receive what you are requesting, and court has signed the order.
Thank you, Your Honor.
We'll
I'll
get
be-
you copies.
May I take them downstairs and get true copies? Is that possible? Or do you?
Do you need a true copy? You have to pay for that. I think that we'll just get you copies. Do you need it because it's going across lines? Do you need the seal? If you do, you have to pay for that downstairs. Otherwise, we can just give you copies, and that's good. I think.
Copy's great. That copy's great, Your Honor.
Yeah.
What I'll do is I'll be filing my default when I think it's 3 days, the deadline runs, and then I'll come in for a motion for a default judgment because I'm requesting equitable relief.
So
I'll see you in about a month and a half or so.
Okay, so here's the deal. My docket is, and I'm going into like a month-long trial, so my docket is really congested. So if I were you, I would go back, look at your calendar, go back and get on my docket today.
Perfect.
Anticipating you're going to file that. You can always remove it, but I ask you to get on there and then please remove it if you don't need it.
Sounds great, Your Honor. I
All
appreciate
right,
that.
so Brian will let you back and we'll talk to you.
Thank you.
All right, and then we have one more civil.
Wait,
Unless
It's fine.
it's a settlement.
All right. So, who's here in regard to the settlement conference on Ferone versus water line? Yeah, you've been here all afternoon. Sorry about that. I've seen you.
Judge, as
Do
soon
we
as
need
you're
to
done
go
with that,
to, I'm sorry.
that young man's been sitting here since 9 a.m. to
Wait.
get his final pretrial that was scheduled for 9. Can we do his next after these gentlemen?
Yes, absolutely. So do we need to do this on the record or would you like to, what are we doing here? And this would be docket, are we going on there? I don't know.
We do not, I think for Your Honor, we may not need to go on the record. I can tell Your Honor that I'm hearing the opposing counsel and I have talked, we've made progress. In fact, we've agreed to a bench trial and opposing counsel has an order in that
Okay.
regard.
Great approach. Sorry you had to wait here all day for that. You know, you always can approach and say, I just need 2 seconds. All right, and then do we have a bench trial date?
We do, it's in April. I don't have the specific date,
As
mid-April.
long as we have it, I don't let anybody leave without a date.
I think we have a date.
And Your Honor,
We have a March pretrial date, Your Honor.
I'm hearing things from, defense counsel that I'm not gonna go into details, but I think he and I are gonna talk and we're it's possible. The first time, I think I'm hearing things that make me optimistic we might be able to resolve the case.
Great. So let me just. Can you tell me on the versus Lansing water line with the trial date is in order? Or do you, okay. 22.
Your Honor, if I might,
At what time?
we checked our file, it's April 10th.
Okay, I just called and thank you for that. I signed this and the jury trial is April 10th at 9 AM and the pretrial will be March 4th at 1 PM.
So it'll be a bench trial on April 10th.
Oh, I'm sorry, bench trial. I wrote jury trial. Let me see. We can fix that and say bench trial.
Bench trial.
It's so rare to have a bench trial, so. Okay, we're gonna make 2 copies, and is there anything else I can help you with?
What, everything else?
If you settle, please let me know these dates are off.
We're trying.
Of course, yeah.
For the first time, I'm optimistic.
Yeah.
All right, well, that's great. Great to hear. All right. Sir, come on up.
This is Ratavian
Where's the phone?
Kinney's?
I think it's from,
Okay.
Rankins, I apologize.
sorry. Just to be clear, Judge, I don't know if we're on the record yet. I'm filling in for Derek Etheridge.
Okay, I'm so sorry you've been here all day, sir. Hopefully we entertained you a little bit. If that ever happens again, let us know. And
Yeah, it's not really.
I'm not ready.
that's okay. It's on page 2, it's the fourth one down. When you're ready. This is 25-4578 FH, People of the State of Michigan versus, is it Ratavian?
Yes, ma'am.
The Rinkins?
Yep.
All right, thank you. Your mother liked to rhyme a little bit. I like that. Yeah, I like that. All right, counsel, your appearances for the record.
Good afternoon, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
And good afternoon, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Mr. Ringtons. I'm here standing in for his attorney of record, Derek Etheridge, who was here this morning, but has another obligation that he had to be at. I'm still here for on a number of cases, so I'm filling.
Appreciate you filling in. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth and the only truth?
Yes.
Thank you. Put your hand down. You taking any medication yesterday or today?
No.
Any sign of fever, cold, or other illness?
No.
Is there medication you're supposed to be on that you're not?
No.
Have you had no time to talk with Mr. Palmer, even though he's your stand-in attorney today?
Yes.
All right, and previously you've talked with Mr. Etheridge?
Yes, ma'am.
All right, and was there a plea offer?
Yes, Your Honor. There was a plea in this case to count 1 as charged carrying a concealed weapon. However, that the people would have no objection to HYTA deferral.
So is he rejecting that or taking it?
Well, Judge, so let me just be clear that I'm sort of following instructions at this point. I just had the pleasure of meeting this young man. My understanding is this: what the defense is asking for is a status conference to be set in 2 to 3 weeks. The issue being that apparently just within the last week or so, maybe 2 weeks, the defense has identified another witness who investigators from my office have talked to that may go directly, ironically, to the knowledge element of the CCW charge. We as in the public defender's office have interviewed that individual, and my understanding from Mr. Etheridge is that the investigator from my office who talked to this potential witness is in the process of drafting up the equivalent of a police report, but from the defense side, to provide to the prosecution so that the prosecution can do investigations should they choose to do so, which may or may not have an impact on the plea offer. But that said, I think it is an obligation by my office to investigate any and all potential leads that could lead to a claim of innocence, and therefore we're asking for that status conference to be set. My understanding from Mr. Etheridge is that my client is otherwise fully compliant, has been compliant. I don't believe there's been any issues to my knowledge. He shows up for court, obviously he waited, since 9 a.m. this morning, not the court's fault, but he's a patient young man, obviously. And so we're asking for that status conference. I was told to ask for 2 to 3 weeks. I realize we're at the mercy of the court.
I picked out a date.
Thank
Any objection by the people?
Your Honor, this is the first time, oh, I will say I did talk with Edford this morning and was informed about this information, so the people have no objection to a status conference.
All right, sir, are you working or in school? What are you doing?
I'm working now.
Where are you working?
I do construction, I'm a contractor.
Construction, okay. So is there a time of day on a Wednesday that's better for you?
Not really, any time of work.
Well, what I have set this for, and if this goes away or whatever, let me know, but I'm looking at April 1st at 11:30. Does that meet with everybody's schedule?
Sure.
We can do that, Your Honor. I will say that the jury trial on this case is set for March 6th.
Not anymore.
Understood.
I don't know that this is first up. This is a 25 case, and I want you to get rid of the jury trial. We'll move the jury trial. We'll decide on that April 1st. I don't know, given what I just learned, that anybody would be ready for jury trial if there's other witnesses or evidence. So,
and I would agree.
So that's got to go away, and we will look at what I'm going to do is put this as a status conference / final pretrial / possible plea. You got your pick.
Understood, Judge. That works for us. I think that's absolutely sufficient time to get whatever it is that Mr. Etheridge and the investigator need done. I can tell you that there's lots of notes in this file, so it looks like they've been doing a lot already, but.
All right, great. Bottom line conditions are continued. Thank you for your.
Thank you, Judge.
That's all. Next, because I've got weapons court soon, so I think, Mr. Palmer, did you have a few people who didn't appear?
Yes,
do,
Your Honor.
Judge, I can put them both on the record. Let me just say goodbye to them.
Dashi Duncan first, since that was.
Well, let's call her.
Dashi Duncan, yep, it was at noon.
I don't know what she's doing, that's just,
I showed you that I had the email first, then like.
We're doing next, Mike.
Duncan.
Duncan,
Okay.
and then Odrin,
Next time you bring it back on the record.
Donald Odrin, he's at 1.
Mr. Duncan was here.
Yeah.
This is docket 24689 FH, People's State of Michigan versus Dashi Duncan. Counsel, your appearance for the record.
Good afternoon, Your Honor. AP Barbuckson on behalf of People's State of Michigan.
Good afternoon, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Dashai Duncan, who is not present today.
He was present earlier. We all saw him, and then he decided to leave. I appreciate today was a very long day out of our control for many, many reasons. On behalf of the people, what would you like me to know?
Your Honor, the concern that the people have is Mr. Duncan has been set for a plea. I see 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. This will be the 10th plea that Mr. Duncan has been set for because Mr. Duncan continues to fail to appear to the hearing. I understand that he has transportation issues, but we have to move forward on this case, Your Honor. The people are concerned that Mr. Duncan seemed to appear prior to noon and then left before noon, which was when this hearing was actually set for, and did not have a chance to talk to Attorney Palmer, is my understanding. So the people would be asking for a bench warrant in this matter, Your Honor, based off the numerous times that Mr. Duncan has failed to appear, and this weird instance this morning where he showed up prior to the hearing and then left before even talking to his attorney.
Well, he's young and has a short attention span, I'm sure. Mr. Palmer, what else would you like me to know?
Well, Judge, that's, first of all, to be clear, I did not personally see Mr. Duncan present, but I've been told by numerous individuals that he was in fact here and present, was asking for me. Part of the issue is that Mr. Duncan does not have a great reliable telephone number, and so I have to relay his information to him through a third party. I was able to actually reach him later this afternoon. He confirmed that he was present. My understanding is I think that he was supposed to try to get to work. He said, he advised me that he was present, that he was looking for me. At the time, I was down running a contested hearing in Judge Jamo's court, so no, I guess others didn't know my whereabouts. He advised that he had to get to work. He thought that maybe because he's never showed up and I wasn't here, he thought that maybe the hearing wasn't going or something today. He apparently was confused. He was also worried about missing the bus. And so he reports to me that he took off sometime after the noon hour. I think it sounds also based on my conversation with him that there was a confusion about what time his court date was at. I guess he thought it was at 11, not noon.
Okay, so what are you asking?
I'm asking that the court hold off with a warrant. I know and provide me with an opportunity to get him turned in. I do think that I can get him here. I'm worried if the court gives me 24 hours, I'm worried about getting him tomorrow just because I am scheduled to be at the district court tomorrow for prelims. Thursday and Fridays are prelim day at the 54 district court.
All right, Mr. Palmer, you can stop dancing.
Thank you.
February 4th at 11:45.
February 4th at 11:45, and I'm guessing this
He
is
can
his.
sleep in, he can summer ride, you can go pick him up, but if he is
No.
not here, he leaves early, whatever, I mean, we're gonna have a bench warrant, and he's not getting out anytime soon until the resolution of this case. 10 times, that's unheard of. We've had a problem with him. I don't know if he has short attention span, needs to be on some medication or whatever, but we gotta rein him in, and the way we do it is jail. So there's your week.
Got it, thank you.
You understand that music?
Yes.
Great, play that song to him.
Yes, ma'am.
Anything else for the record?
Not for this record.
Thank you, that's all for this record.
Can we call Odrin next?
Yeah, sure.
I'd just rather not Milks be called yet, because he just got here.
Yeah.
He
Oh,
should,
sure.
he should wait. He
Just
should
give me,
wait.
give me 10 seconds here.
I don't see that.
If you keep this up, Palmer, you're gonna be wearing ballet shoes in front of me.
I don't see that.
Which one?
Donald Odrin?
Oh, yeah.
That one.
That one.
Donald Odrin.
Oh, probably because I didn't grab the other news today.
I can give you.
All right, this is docket 25-907FH. People of the state of Michigan versus Donald Albert Odrin. Counsel, your appearances.
Good afternoon, Your Honor. APA Burt Buxton on behalf of the people of the state of Michigan.
Thank you, Your Honor. Robert Palmer, of the Public Defender's Office, on behalf of Mr. Odrin, who's not present. I already told Mr. Buxton I can give you the 30-second version so you can continue the warrant. I don't
Is
know
there
why.
already a warrant?
I think so. I'll tell you what happened. This guy, on this case, I made a bond argument. You let him out to go to treatment. He got to treatment and apparently made it less than an hour before Brian
Yes,
started
I
calling me.
remember I
upset.
signed that warrant.
So he was in warrant status for 6 months or so. He got back with a new case. He has a new case that's on its way up to you that John Lee from my office represents him on. And he showed as being in custody. I went to schedule a polycom with them at the Ingham County Jail and they said, we don't have it, even though he shows up on the Ingham County Jail website. I called the Ingham County Jail yesterday. I said, where is this guy? And they said, he posted bond on December 30th. And my response was, can one of you guys come down and tell Judge Aquilina that? Because he's got a warrant and she's not gonna be pleased.
Yeah, I'm not gonna be pleased. So bench warrant, bond forfeiture, if it's already there, it will be, it will continue. If it's not there, it is now.
Thank you.
Thank you. We'll let you know when he shows up.
Thank you, Your Honor.
It's all for that record. Next.
Okay,
I'm not ready.
Yeah, I know. I just need to know what the next one is.
Antoine
So I can be
Nance.
ready. Huh?
Antoine Nance.
How many words do we have?
I think this.
Is this
it? I don't know.
Oh, no, we have Mr.
Oh,
Mills. What do you
no,
have?
this
Bill?
is it. Mr. Mills.
Are you just being entertaining?
No. Well, yes, but,
He has a 3 o'clock hearing.
You have a 3 o'clock hearing?
with Jonathan for Cantu, Jonathan Foreman,
Class.
Okay, what kind of hearing is that?
pre-trial.
Oh, I got you. So you guys can go in the back in a moment. Because I'm not involved in the pretrial, correct?
I think we're just putting it on the record.
It's a final. It's a final.
Oh, it's a final.
Yeah, I'm
Okay.
sorry.
Well, you know what? I'm sorry. Have a seat, sir. We're gonna do the final pretrial, which will take all of 4 minutes and, yeah, just have a seat at council table.
So which one is this
Mr. White.
one?
This one is Jordan Cantu. That's 3.
3 o'clock.
All right, when you're ready. This is docket 252745FH, People of the State of Michigan versus Jordan Cantu. Counsel, your appearance for the record.
Good afternoon, Your Honor. Burt Buxton on behalf of the people of the state of Michigan.
And good afternoon, Your Honor. Stephen Milks on behalf of Mr. Cantu. I'm also joined by Jonathan Foreman from my office, Mr. Cantu appearing from Eaton County Jail via Zoom at this time.
All right, sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury? Can you hear me, sir?
Mr. Cantu, that was for you.
Yeah. Okay, did you hear? Do you swear to tell the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand. Have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
Can you repeat it?
Any sign of fever, COVID, or other illness?
No.
Have you had enough time to speak with your attorneys? Have you spoken with your attorneys?
Yes.
All right, so, this is a final pretrial, and you are charged before this court with count 4 criminal sexual conduct, first-degree injury to the incapacitated victim, and that is punishable by up to life, and count 5 criminal sexual conduct, first-degree injury to incapacitated person that is also punishable by up to life. Has there been a plea offer in this?
Your Honor, I had a chance to talk to Attorney Milks via email. It is my understanding that they believe this is a triable case and they wish to go to trial on this. Unfortunately, our office, I'm new to this file. I have not had a chance to talk to the victim. And as this is a CSC first, this is also a case that needs to go in front of the elected John Dwayne. So I wanted to talk to Attorney Milks to see if there was even could even have plea discussions. My understanding is that they want to have plea discussions, but they also believe this is a triable offense, so I'm not quite sure if.
Okay.
So there has been no plea offer given at this point in time.
Great, so understanding that, what is the trial date?
The trial date is February 27th.
No, it's not. This is a 25 case. Let's have a real date, because I have older cases, as you know. And we have probably a month-long jury trial, so.
And I'm sorry, Your Honor. Mr. Cantu is currently serving time in Eaton County Jail. His release date, I believe, is May 7th. So if it's sometime after May 7th, he'll be transferred, I believe, back here with the $50,000 cash free bond. I think it just makes it easier for getting him here, getting him in court, make sure he's got proper clothing.
All right, June 12th at 9 a.m. I don't know, I'm sort of shooting from the dark. I don't have my full docket, I don't know if it's criminal or civil, but I'm gonna say June 12th at 9 a.m.
I do have it right here, Your Honor, I can look. June 12th is a civil day, June 5th is a criminal day.
All right, June 5th. June 5th at 9 a.m. And we'll have a final pretrial, when does he get out?
May 7th, Your Honor.
All right, so we'll have a final pretrial May 20th, unless you want it the 13th.
May 20th is perfect, Your Honor. Thank you.
And that would be May 20th at 11:30.
Thank you, Your Honor.
Thank you very much, Your Honor.
He was raising his hand.
Who was?
Sir, did you have a question?
No, I think you're trying to communicate May 5th, Your Honor, which is his out date.
I'm sorry, what? His out date is May 5th?
Yeah, he was trying to communicate that, I believe, Judge.
Okay, so are you good with the dates then, Mr. Foreman?
I won't be available May 20th, but I know Mr. Milks can handle it.
Are you good with that, or you want me to move it?
I'll leave that to the court.
I don't care, I can move it to May 13th or May 27th, May 27th is too, I think we can move it to May 13th, I just wanted to give him the time, a week or two after he was out, so.
We're fine with May 20th, Your Honor. I'll make sure.
Right. Great, all right,
Thank you, Your Honor.
thank you, that is all for the record. All right, now we are on docket 22. Okay,
I still
sorry.
got, I still got.
I know, I'm sorry.
It's okay.
It's been a. It's been a. Sorry about that, Mr. White, but I didn't want to keep the jail waiting. It's more of a courtesy to Eaton County, you know how they are, they just go off and lose connection.
No problem, Your Honor.
So sorry about that. All right. Are you ready? All right, this is docket 22-806 FH, People of the State of Michigan versus Antoine Nance. Counsel, your appearance for the record.
Good afternoon, Your Honor. AP Court Books on behalf of people of the state of Michigan.
Good afternoon, Your Honor. Toby White here. On behalf of Mr. Nance, who's at the podium with me, and I should be clear that I am here on 22005024,
Oh,
and that there is an additional file, but
Need that.
that file is to be dismissed with the plea and sentence going forward on this case.
okay. So I have
I might have a
22-806 FH.
Correct.
That's right.
I believe Attorney White was referencing the prosecutor number.
Oh.
That's correct. I was reading the wrong line.
Okay, I'm making sure. It's been a long day. I would have certainly accepted that I was wrong. But I have Mr. Lee who has signed this.
On the 25 case, Your Honor, 25-6168 is the case that Attorney Lee is on.
Mr. Lee sent an email and is, because the court asked if the court was okay with it, he would be, that Mr. White would just be standing in, and Mr. Lee indicated, yes, Mr. Nance, he was okay with that as well.
Mr. Lee indicated what?
Mr. Lee sent an email indicating that he would not be able to attend this afternoon's plea, that he had a conflict. He indicated that he spoke with Mr. Nance, and Mr. Nance is okay going forward with the plea without him being present. Oh, sorry, Nancy.
I'm gonna try with him one more time. I'm just kidding.
No, not
So
really.
Mr. Lee will be here for sentencing.
Correct.
He will,
All right.
although his file will be dismissed as part of the agreement that I've already presented to the court that
Okay,
Barbie
so
also signed.
do you need to sign this? I don't see your signature unless I just can't read it.
There should be both signatures. I believe Attorney White mixed up the lines and he signed on the defendant's line and the defendant signed on his line.
Okay.
And then Attorney Lee signed at the bottom of the plea.
I made an accident. I signed first.
Okay. Okay. Great, okay, well. Okay. All right, I'm sorry, it's been a day. Did I swear you in?
No.
Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Raise your hand now. So have you taken any medication yesterday or today?
No, ma'am.
Any sign of fever, cold, or other illness?
And to speak up a little. So
No.
Is there medication you're supposed to be on that you're not on?
Vicodin for my knee.
But you didn't take that?
No.
And so are you in so much pain you want to move this to a different day, or are you okay not taking a medicine?
No, I'm okay.
Okay, now, if you have pain in your knee, would you like to sit down during this? You can certainly sit down. I don't have a problem with that.
Okay.
Let's get him a chair. Or you can sit. Yeah, you just- All right, so if he's gonna sit there, I need you to both be speaking loud and into the microphone, okay?
Turn the mic on.
Mic on?
Yes, please.
All right, is that mic on? Mr. White, can you say something?
Hello?
No, it's not on.
Is it coming through, Nancy?
No, we're gonna get it on in a minute. Council mic, we need the council mic on. Hello? Yes.
Did that work? Hello?
Is
I think
it?
it is a little, yeah.
I think that would have been me moving the mic.
Oh, that-
Sorry.
Is it working?
Hello? Yep.
Now it's better. All right, very good. Thank you. Just had to probably put the volume on. All right, so I understand there's going to be a plea.
Yes, Your Honor.
And sir, do you live on Jolly Road?
I stay on Richmond.
What's the Jolly Road address?
That's where my mom passed. I woke up to my mom going,
Oh, I'm sorry. So what is your current address?
4729 Richmond.
Is that Lansing?
Yep, Lansing, Michigan.
48910. Okay, so it's the Jolly Road address. Nobody's there anymore. All right. And are you employed?
Currently, working part-time on painting. I
Okay.
received disability.
Okay, so are you working within those rules then?
Yes.
All right, that's fine. And you're a US citizen?
Yes.
I understand there's going to be a plea. Were you on probation, parole, or bond conditions on another file at the time of the offense that you're pleading to?
Probation. I got blown up in the basement and it messed with my probation. So they were thinking that I just didn't go, but I was handicapped for 7 months.
Oh, was that in front of me or someone else?
In front of you.
Okay, so what did I, or is that still pending?
That's over here to plea on.
Yeah.
This is a 22 case.
I believe he's saying he was on bond for the
For
22
this
case and the
file.
25 case happened.
I believe that's correct.
Okay, so I'm very, very confused here. Is he pleading on the 22 case or the 25?
He's pleading on the 22 case, the 25 case will be dismissed.
Okay, and what is the number? Let me see. It's on here.
It should be at the bottom of the case is being dismissed, Your Honor.
It's, unless I don't see, oh, I see it. Wait a minute. Oh, no. Okay, so the docket 25-6168 FH is going to be dismissed in its entirety, correct?
Correct, after a successful plea and sentence.
That's correct, Your Honor. I'd like to make one inquiry if I may.
You mean?
You understand that the public defender, Mr. Lee, represents you on 25-6168 FH? And you had discussions with him about me representing you here today entering this plea, even though it impacts that case that Mr. Lee is your appointed attorney for. Understand what I'm saying? You're okay with me representing you entering this plea, and then Mr. Lee's case will be dismissed?
Okay.
Okay. Okay. You're
Yeah,
okay with it?
yes.
Okay, thank you.
All right, and we're gonna get you copies of all this. And is there a sentencing agreement or no?
There is no sentencing agreement, Your Honor.
Okay.
And I can read the counts he'd be pleading to in 22-806 if the court will.
All right, and so counsel, are you waiving reading of count 1, 2, 4, and 6?
Yes.
And then you're also waiving reading of the entire docket of 25-616 FH.
Yes, Your Honor.
And as to the reading of 3, 5.
And it will be an added count 7, Your Honor, on an amended information.
All right, and what we just stated is full, fair, accurate, and complete in terms of the agreement?
Yes.
Your Honor, I don't think we actually mentioned what the plea is on the 22 matter, so.
Yeah, well, let's go ahead. I mean, I understood it from our conversation, but
Yes.
to be clear, let's put it on.
Yes, so in 22-806, the defendant will be pleading to count 3, felon in possession, count 5, fleeing third degree, and an added count 7 of possession of controlled substances, narcotics less than 25 grams. The remaining counts, as well as 25-6168 FH, would be dismissed in its entirety. This is included in count 3, but there would be a forfeiture of all contraband seized as a result of this case.
That is complete and accurate.
Sir, is that your understanding?
Yes, ma'am.
All right, and it's full, fair, accurate, and complete?
Yes.
Mr. White, full, fair, accurate, and complete.
Thank you.
And counsel, if you could read the 3 counts that are left.
Yes, Your Honor. The people of the state of Michigan versus Antoine Lionel Nance, State of Michigan, County of Hingham, in the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on or about September 23, 2022, at Turner Street / Douglas Avenue, City of Lansing, Hingham County, the defendant in count 3, weapons, firearms, possession by felon. The defendant did possess and or transport and or carry a firearm when ineligible to do so because he had been convicted of carrying a concealed weapon, a specified felony, and the requirements for regaining eligibility had not been met, contrary to MCL 750.224F. This is a felony that is punishable up to 5 years and or $5,000, as well as mandatory forfeiture of a weapon or device. See MCL 750.239. In count 5, police officer fleeing third-degree vehicle code. The defendant being the driver of a motor vehicle to whom was given a visual or auditory signal by hand, voice, emergency light, or siren by Trooper Cody Black, a police officer who was in uniform, and the officer's vehicle was identified as an official police vehicle acting in lawful performance of his or her duty, directing the defendant to bring his or her motor vehicle to a stop, did willfully fail to obey that direction by increasing the speed of the motor vehicle and or attempting to flee or elude the officer, and the violation resulted in a collision or an accident, contrary to MCL 257.602A, subsection 3. This is a felony that is punishable up to 5 years and or $1,000. The secretary shall suspend the license for 1 year under MCL 257.319. And the added count 7, controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams. The defendant did knowingly or intentionally possess less than 25 grams of a mixture containing the controlled substance cocaine. Contrary to MCL 333.7403, subsection 2, subsection A, subsection V. This is a felony that is punishable up to 4 years and or $25,000. The court shall order law enforcement to collect DNA identification profiling sample before sentencing or disposition, if not taken at arrest, and against the peace and dignity of the state of Michigan.
Sir, did you understand what was just read?
Yeah, I heard.
Do you have any questions about it?
No, ma'am.
All right, so you understand count 3, weapons, firearms, possession by a felon is a felony punishable by 5 years and or $5,000. There's mandatory forfeiture of weapon or device, and that would be true for all contraband, any weapons, ammunition, drugs, paraphernalia, whatever, that is all forfeited. Do you understand all that?
Yes.
And then as to count 5, police officer fleeing third degree under the motor vehicle code, that is a 5-year felony and or $1,000, and the Secretary of State shall suspend your license for 1 year. Now, I don't know, you can talk to counsel if you need a restricted license or what have you, but that's a different conversation.
Would I be able to pay on like the fees?
So they're gonna impose some fees. They are, I don't know what they are, and then there's, after a certain time, I believe, but I don't know because I don't have them all memorized. You may be able to get a restricted license. They may deny you, then you'd have to come here to talk to counsel about it. And you can show hardship or what have you, but there's a process for that. So you'll have to go through that. A year's a long time in this community because we only have Catabus doesn't run all the time, and I mean, you can Uber, but that gets expensive, and so it's a hardship. So I don't know all the rules on that. Do you want a minute to look that up with counsel? I don't know.
No.
All right.
I just feel terrible for like all the trouble I got into, and I got 3 kids of my own. I got 2 boys and a baby girl.
Yeah.
And, like I'm totally done with it. It's giving me gray hairs from stressing out. I'm only 37, so I really want to apologize for anything that happened here.
I appreciate that. In sentencing, we'll talk about that, but I appreciate that you're thinking about that now, because here's the thing. Just turn on the news, look at the papers, Google it. Children are dying every day because of guns, every single day. And same with drugs. You know, if you use it, sell it, whatever, you're involved with it, that just means that your kids at 9 are also going to be exposed to it, because it's never an end. It's easy money, it's an easy way to check out. There's lots of things, but so we see generations of people addicted and dying from these drugs. So it has to stop. So the fact that you recognize bad decision and it will affect your children, not only because you're a felon, but because you're putting this bad stuff in the community, that's really the first step to making a change. Everybody makes mistakes. It's what you do with the mistakes. Mistakes are teachable moments that actually are the deciding point of, are you going to excel in a good direction or decline in a bad one? And so now is your pivot point. You decide what you want to do, and what I'm hearing is that you want to go to the top of the mountain, not the bottom. So be the example for your children in the community, okay? And this is the first step. And I'm a judge who believes in rehabilitation, but if you decide to go backwards, I'm also happy to put you in prison to save your life and others. Understood? All right. And so, sir, you also understand count 7, possession of a controlled substance known as cocaine less than 25 grams is a felony punishable by 4 years and or $25,000. And I don't know circumstances here, if there was any buy money or any of that other kinds of things or whatever happened here, I learned, but you may be responsible for cost recovery. And again, the drugs are forfeited. You understand all of that?
Yes, ma'am, that's a bad habit that I'm kicking totally.
All right, well, we're gonna get you some rehab for that, all right? So, are you in rehab now?
I was at Bear River for a month.
Okay, did you finish it?
Yep,
And so you're doing aftercare?
yeah, I'm about to start going to, what is it, CMH, Community
Yeah.
Mental Health.
Yeah.
And it's gonna help me, because like after I lost my mind, I got really bad in doing
Yeah.
coke. I'm not gonna lie to you now. And I made.
Okay, but you know what? Your mom's right there standing behind you saying, you gotta honor me, what you doing? Right? So you honor her life by being happy. That's what she wants for you. And believe me, I'm a lot older than you. Twice your age. And every year you live, it gets faster and faster and faster. You probably have already noticed that, right? But wait till you're my age. Before you know it, you're gonna be saying, hello, Mom. But she doesn't want you to say hello to her until it's your time, until you're old and really gray. And your kids need you, and they need you to be clean and sober and not in prison.
Right.
So your mom and God made sure you were in front of me. So let's honor the agreement that your attorney and the prosecutor put together for you. Honor the law, orders of this court, your family and your community and your kids. And this will be behind you before you know it. But being honest and humble is really the first step. So you've taken that. So I'm glad to hear you like Bear River, you're doing the aftercare. So we're going to talk more about that at sentencing. And so any of that documentation, give to your lawyer and to probation. So it's in the report. We'll talk more about that at sentencing. And you just remind me, because I see a lot of people. I'll probably remember you, but who knows? All right. All right. Any questions?
No.
All right. Now, it looks like you signed the advice of rights form. Did you read it before you signed it?
Pretty much, you know,
Okay, did you have any question? If you had questions, was your attorney able to answer those?
yes.
Did you need more time with your attorney to go over your rights?
I suppose.
Okay, we're gonna give you a copy, or do you have questions of me of your rights?
Not really, we covered everything pretty much.
You want me to go over your rights with you?
Yes, if you could.
Okay, so let me talk about by pleading, because you're gonna plead today, right? That's your intention, at least. You haven't done it yet. But by pleading, you are giving up your right to a jury trial or a bench trial. You do have a right to presumption of innocence until proven guilty beyond a reasonable doubt, and that is solely placed on the people. And that would be at bench trial or jury trial. You have the right to cross-examine any witnesses and evidence brought against you, and that presumption of innocence continues throughout the trial. You don't have to do anything at all. It is their sole burden. And you can choose to provide a defense, but you don't have to do anything at all. If you choose to provide a defense and you bring witnesses, the court would order those witnesses to be present, and you can also bring evidence in your defense. And the people could cross-examine any witnesses and evidence you bring. You have the right to remain silent. You also have the right to testify. If you remain silent, your silence cannot be used against you in any way. If you choose to testify, however, you people could cross-examine you. Additionally, by pleading, you're giving up an automatic right of appeal. If you have a bench trial or jury trial and you are unhappy for any reason, and I do mean any reason, the Court of Appeals must take a look at your unhappiness. But by pleading, it becomes their decision. You have to ask them permission to appeal, and they will decide whether or not to grant you that. But it's decided based on whether they think your issues are important or not important. Do you understand that?
Yes.
All right, and then after you plead, if that's the way you want to go today, you'd have 42 days to appeal and to request appellate counsel at the time of sentencing if you are unhappy with what happened. Now, do you have any questions about that, or do you need more time, counsel? Are you satisfied with what I said in terms of your rights? Anything you want to add?
I'm satisfied, and we did go over it. I'm glad he had the opportunity to ask you.
And so, sir, did you have any questions for me?
No, ma'am.
Okay, and did you need more time with me or with the court, with your attorney?
No. We're pretty much sure. Yeah.
Okay.
You agree with what we're gonna do and understand the agreement? You want to go forward with that this afternoon?
Yeah. Yeah. That'd be, yeah. Yes.
And sir, at this time, are you ready to plead?
Yeah.
All right, as to count 3, weapons, firearms, possession by a felon, how do you plead? Guilty, not guilty, or no contest?
Guilty.
And sir, as to count 5, police officer fleeing 3rd degree under the motor vehicle code, how do you plead?
Guilty.
And as to the added count 7 on the amended information that will be filed, possession of a controlled substance known as cocaine less than 25 grams, how do you plead?
Guilty.
Now, sir, has anyone told you what I will do at sentencing?
No.
And that's because I don't know. I don't know anything about your case right now. At the time of sentencing, I will be fully informed, and then I'll make up my mind. I will learn a little bit today, but I don't know a whole lot about it now, so I'll make up my mind. So if anybody told you anything, they'd be wrong, because there's no such thing as a crystal ball, as much as we all want one, right? Okay, and sir, you understand the right, we've gone over your rights, and you understand you're giving up those rights by pleading, like the presumption of innocence and your automatic right of appeal. You understand all of that?
Yes.
Okay. And sir, if someone forced, threatened, or coerced you to plead, so that the plea to these 3 counts was not your own choice, you need to tell me that now. If you come back later and say, Judge, I shouldn't have pled, I don't have to accept that. Do you understand that?
Yes.
So my question to you is, have you pled to all 3 counts of your own free will?
Yes.
And you did that after you consulted with Mr. White and Mr. Luke, your attorneys? Yes?
Yes.
And you've been satisfied with their representation, is that correct?
Yes.
All right. So I'm going to ask you some questions. If you need me to rephrase or repeat, please let me know, okay? Did these offenses occur on or about September 23rd, 2022? I know it's been a while ago, but.
Yeah, my memory is pretty bad.
All right, but you're not disputing it occurred then?
No.
All right.
I'm disabled, and it's not an excuse. It's something I have to deal with my whole life.
All right.
You know?
But you're not disputing it. If the felony information, you would have been arrested, and that you would have been arraigned on all of that, and you're not disputing it occurred sometime in the fall of 2022?
No.
All right. And that would be in the city of Lansing County, Bingham, state of Michigan?
Yes.
At a specific location known as Turner Street and Douglas Avenue, you came in contact with law enforcement. Do you remember that?
Precisely, yes.
All right. And at that time, why did law enforcement stop you or come in contact with you? Do you remember?
I was supposed to be speeding down the street.
So you were in a motor vehicle?
Yes.
You were driving?
Yes.
And they stopped you for speeding, and did they ask you to step out of the motor vehicle?
Yes,
And do you know why they did that?
probably because I was speeding.
Well, they don't always do that for speeding. Did they see a weapon, drugs? Did you appear high? Why did they ask you to step out of the motor vehicle?
If I may, Your Honor.
You may.
So Mr. Nance, in that area, Turner Street and Douglas Avenue, the police pulled up behind you, correct?
Yeah.
And you didn't want them to stop you and look in the car, is that correct? So you took off.
I was supposed to be driving.
Okay.
And yeah.
All right, so that was your reason for what we call fleeing or eluding. You drove away, accelerated in your speed, hopefully to avoid being stopped. Is that correct?
Yeah.
You knew there were a police car and they had a light, and you knew they were trying to stop you.
Well, yeah, I was in panic mode.
Okay, so that's okay. So you see the cop car behind you and you're saying, oh no, and you speed up when you knew you should slow down. So that's where the fleeing comes in. Would you agree that you should have stopped and you didn't?
Yes, ma'am.
And then did you eventually stop, or was there an accident, or did they
My
catch up with you
tire
later?
blown on the truck.
Okay,
Yeah.
so,
That's how I slid into the folks that I did, and I felt terrible for that.
okay, so then, when officers then approached you, they asked you to step out of the motor vehicle, they probably searched and handcuffed you, is that correct? Is that a yes?
Yes.
And then did they find a pistol?
They found my coat, and I guess they did say they found the pistol, yes.
Okay, they found your coat in the vehicle?
My coke.
Oh, your cocaine, okay. So where did they find the cocaine?
They found it on me.
And that was on the coat you were wearing?
It was on me, like in my jeans.
Okay, so in your jean pocket, front, back, what?
It was front.
Okay, and
I
you
ended
placed
up
it there?
pulling it out, and
Okay.
yeah, they were right there to assess that.
All right, so they found cocaine in your front pocket, you put it there.
Yeah.
Was it less than 25 grams?
Yeah.
And it's fair to say you didn't have a license or special authority to have that cocaine, is that correct?
Yes, ma'am.
You knew it was unlawful?
Yes.
And was the cocaine tested and affirmed that it was in fact cocaine?
Yes.
It was. It was.
All right, and sir, where was the pistol then?
I was supposed to be in a backpack that was in the truck, somewhere in the truck, like my mind was just racing. I'm gonna get in trouble for this bag of drugs,
Yeah.
which I shouldn't have been doing. And yeah, they ended up taking my mom's ashes too, when they took everything, and I never.
Well, I can order those back, sir. It's
Oh.
probably somewhere in the evidence. I'll get you those back, but right now, can you tell me where was the weapon? Was it in the vehicle?
It wasn't near me where I was driving.
It doesn't matter. Was it in the vehicle?
Yeah, it was in the vehicle.
And you placed it there?
It was in a backpack.
You placed it in the backpack? The backpack was in the motor
The
vehicle?
backpack was already in there.
Okay, but the backpack was in the motor vehicle?
Yeah.
Front or back seat or trunk?
It's front,
Okay,
I believe.
and you placed it there?
No.
It was already, well, at some point, even if it wasn't that day, you placed the
Right.
backpack there, so
Right.
you knew it was there.
The backpack was in the truck.
Okay, and then in that backpack, was there the firearm?
Yeah, that's the whole ordeal.
Okay,
You knew, it was- excuse me, Your Honor, you knew it was there. You knew there was a gun in the car.
Yeah.
all right.
After they pulled it out, I was like, yeah, it's there.
And you were not yet eligible to have a firearm, specifically this pistol that you had, because you'd been convicted of carrying a concealed weapon, and the requirements for regaining eligibility had not yet been met. Is that correct?
Yes.
All right. On behalf of the people, any additional questions?
People are satisfied, Your Honor.
On behalf of your client.
Satisfied, Your Honor.
All right, thank you. Are counsel aware of promises, threats, suggestions, or inducements other than those already placed on the record?
No, Your Honor.
I am not, Your Honor.
Has court complied with the court rule?
You have, Your Honor.
Yes, Your Honor.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, counts 3, 5, and 7 will enter. Counts 1, 2, 4, and 6 are hereby dismissed, along with docket 25-6168FH in its entirety. All contraband on all files are forfeited. And any outstanding warrants on either file are hereby recalled and dismissed, if any. As to any personal items that are not part of an investigation, such as his mother's urn, that will be immediately returned. There's no reason to keep that. The rest will be forfeited. I don't know what else you have in the car, but it's probably in some box with your name on it. They'll have to dig it out and get it. That will be returned to you by order of the court. If it isn't enclosed, whatever it is.
Some of mine, 2 glasses.
Okay, so I don't know if you have a list, or you can provide your attorney with a list, and then whatever else is not contraband. And I can certainly sign an order so that law enforcement knows exactly what they're looking for. I don't know about the clothes and all the other stuff, but I think your mom's urn is probably.
Definitely, like, yeah, screw
Yeah.
the car and everything, but I'm wondering if I'll get her truck back.
I don't know why you wouldn't. Were you driving without a license?
Yes, ma'am.
Okay, I don't know if that, I have to, you weren't convicted, it's not on here. So I don't know, but anything that you should get back, you get back, and counsel, if you, and Mr. Lee want to draft an order, I'm happy to do that, and then in terms of your car, whose car was it?
So my mom.
And, are you the sole heir of your mom's estate?
I didn't hear your.
Are you the sole heir of your mom's estate?
Yes.
Do you have siblings?
I have like 3 sisters, 4 sisters.
Did your mom leave her estate to all of you, or just you, or what?
Yeah, it was just mainly me, and then we ended up parting out the belongings, like the nice dolls and everything in the house, but mainly I solely was in charge of.
Okay, did she have a will?
I used to stay with her.
I did that with my folks too, it's tough but rewarding. But let me just ask you, did she have a will? Okay, so.
She was on disability too.
Okay, so she died intestate, meaning without a will, so that you and your 3 sisters would then divide it equally, and it sounds like you guys didn't fight, you divided things. As to the car, if that's something that you got in the estate, and maybe you were not lawfully entitled to it, perhaps one of your sisters could claim it and sell it.
Yeah, my sister has the title.
Does she? Okay, so if she has the title, whatever you work out between you, I don't care, as long as it was compliant. The order could say that she can go and claim the car if they would pound it.
Okay.
Does that make sense to you? I'm sure Mr.
Yes.
White understands what I mean, and we can get that taken care
We'll be happy to counsel.
of. Okay, do we have a sentencing date?
March 18th at 11 a.m.
Does that meet with everyone's schedule? Did you say 18th at 11?
Correct.
If you need to change it, that's fine, but we're gonna leave it at that date. I know Mr. Lee's gonna be here, otherwise counsel, you or your associate can be here. Sir, you'll need to go down to probation, make and keep an appointment with them. They're going to do a very detailed pre-sentence investigation report. You have to call them within 24 hours. The number's 483-6100. It's on that purple sheet. Your counsel can direct you downstairs. It's best while you're in this building to just make that appointment. If you do not keep the appointment, I can't get to sentencing, and that means that I will have to have you picked up and sit you in the jail until probation deems it in their heart to come see you. So don't make that happen. Keep the appointment. If you're ill or something prevents you from showing up,
March
you call and reschedule.
That's the same day as March 18th.
No, that's the 18th is when you're being sentenced. You have 24 hours to make an appointment with probation. They're going to meet with you and give a detailed report that we'll talk about on that date. So counsel, if you could further advise him of that and show him to probation.
Your Honor, I always take my clients downstairs.
I just need to make a record of it, that's all. So you can explain that further. Thank you. That's all for the record. By the mind, conditions will continue. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Is this day over? Thankfully, he needs to get a break. We gotta go to weapons court.
Now we have weapons court next. Luckily, there's only 2 kids.
Yeah. Where are they? Are they in the hall?
They're probably in the hall.
One minute, yes. Okay.
Beverly's probably gonna be up too.